new faces in the crowd, I just wanted to make you aware that if you parked in the structures, you can get it validated. There's a box right outside these doors here. Don't forget to get your parking tickets, vouchers validated right outside there. Okay, the October 12, 2017 Rent Control Board meeting is called to order. Would the secretary please call roll?
Commissioner Flora.
Here.
Commissioner Foster.
Here.
Commissioner Trosis.
Here.
Commissioner Duran.
Here.
And Commissioner Phyllis is absent.
Okay, now I'd like to ask that we all stand for the salute to our flag. Okay, we'd like to move to number 5, the approval of the minutes. May I have a motion to approve the minutes of the board's meeting last month?
Yeah, I move the approval of the minutes.
Okay.
Second.
Okay, there's been a first and a second, and is there any discussion?
Yeah, I
Go
do.
ahead, Commissioner Trosis.
Under 6 special agenda items, I just wanted to clarify that I had 2 different requests to staff, and I was wondering if we could denote them separately. The request to have code compliance come to give an update on the processes between building and safety and rent control. As we've discussed, those are 2 separate agencies. I would like that to be separate and apart from the plan to engage stakeholders in the seismic safety retrofitting process. Just wanted to clarify that.
Okay, friendly amendment?
Certainly accept that. Yeah, that'd be a good. That would be a good clarification. Because they are really 2 different things.
Right, it just looked kind of like one paragraph in one item.
Okay, does the seconder accept?
I accept.
All right, then, since there's no more discussion, we'll take a roll call vote.
Do I need to move as amended, or I accept it as friendly, right?
Yes,
Is that good enough?
Friendly.
I think that's
You can just do it for
enough. Okay,
Okay.
voice vote, please. All in favor of approving the September 7th, 2017 minutes as amended?
Aye.
Aye.
Aye. Okay, the ayes have it. Moving on to public comment. Oh, no, sorry, excuse me. Back to number 6, special agenda items.
Yes, I have a few things this evening. We held our maintenance seminar with the Code Enforcement Division this week, and Mr. Costello and information analyst Karen Evans were there, as well as Armando Rangel from the Code Enforcement Division. It was well attended, and people had good things to say about it, felt that they found it informative, and it was a great source of information. So that was well attended. The next thing that we will be offering will be the forum that we offer with the City Attorney's Office in December. That will probably be either Wednesday, December 5th or December 12th. We haven't yet zeroed in on a date. The other thing I wanted to mention is next week, the City Attorney's Office is having an event related to fair housing. They will be screening, a premiere screening of an animation video about fair housing. It's next Wednesday from 3 to 4:30 at the MLK Auditorium at the library. And it is based on the winning poster from the fair housing contest that they have each year. So it sounds like it should be a very fun and interesting thing. So anybody who's interested is welcome to attend. And that's the first of 3 events that they'll be holding this, the 50th year of the passage of the Civil Rights Act of 1968. So more to come on that in the future. That's what I have this evening.
Okay, very good. Thank you.
If
Go ahead.
I
Yes.
may, Mr. Chair.
Go ahead, Commissioner Flora.
Tracy, is it also worth mentioning the session on November 13th, given the topic tonight?
Well, I will be mentioning that when
Later.
when
Okay.
we're on the item about the seismic
Okay,
safety
very good.
retrofitting.
Okay, thank you very much. Moving on to public comment, I just want to let you know that this is the time set aside for members of the public to address the board on matters that are not included in the agenda, but are within the board's subject matter jurisdiction. So please note that this is your opportunity to speak if you have something to say, but that the board cannot take any official action at tonight's meeting as it may not have been included in the agenda. Okay, having said that, I have one request to speak. Michael Millman, you've asked for 2 minutes. Come on up to the podium if you would.
Good evening, Michael Millman. I'll take quickly, I don't even think I need 2 minutes. I need to express my genuine and sincere thank you to the leadership of this esteemed board, particularly to the administrator. I have felt for years or longer that housing policy, nothing on this agenda, is advanced by a unvarnished type of a free exchange between people who are in a position to consider those opinions. So to those commissioners who took their free time to come out and visit with people that provide housing, and for those people of the Santa Monica for Renters' Rights and others, I can only say from the bottom of my heart, thank you, because these kinds of exchanges that were established and helped by Ms. Condon and others are certainly terrific for having the kind of partnership we need to advance those issues that are important. So Tracy, I liked it. I enjoyed the water, and I particularly enjoyed the company at those meetings. And our doors are always open to our friends that sit at this dais, and I thank everybody that came forward, because it was not only terrific, it was an eye-opener and outstanding, and I thank you for all of that, Mr. Chair.
Thank you. There are no more requests for public comment, so moving on to number 10, jurisdictional items. I am calling now case number E1761-2225, Montana Avenue. May we have a staff report, please?
Good evening, Commissioners. Ms. Chow Chen bought the 3-unit property at 2225 Montana Avenue in December 2012 and currently co-owns it with her son, Roland Chen. Back in 2015, while the board was considering the rent decrease petition of a previous tenant of Unit 2227, Mr. Chen, the son, filed an application to exempt the property as owner-occupied. The board granted a substantial decrease to the tenant who had filed the decrease, but shortly thereafter, the board considered Mr. Chen's application. None of the tenants disputed his claim of residency, and the record otherwise supported it, so the board granted the exemption. As a result, the previously granted decrease became moot. That tenant moved off of the property when the property became exempt. Mr. Gross, the current tenant of Unit 2227, replaced him. Mr. Chen moved to Torrance, and therefore the exemption lapsed in May of 2016. Mr. Chen then informed the board that his mother would be moving onto the property after she had completed construction work to enlarge and remodel the unit that she was going to occupy. Mr. Gross, meanwhile, the tenant in Unit 2227, filed a rent decrease petition in July 2016, again alleging substantial maintenance problems. He was awarded a substantial decrease as well. The day after the hearing officer's decision was issued, Ms. Chen filed an owner-occupancy exemption application claiming to have resided on the property since July 2016. This time, the tenants, however, disputed her claim of occupancy. The board denied Ms. Chen's application because she had failed to provide sufficient evidence to show that she had resided on the property as her principal residence. And Mr. Gross's rent decrease remains in effect to this day. In May of 2017, Mr. Gross filed a new rent decrease petition based on the impacts of the ongoing construction on the property, which included the remodeling and expansion of Ms. Chen's unit and the garage below. As soon as the board regulations permitted, Ms. Chen filed a new owner occupancy exemption application this time claiming that she had moved in August of 2016. The tenants have again disputed her claim to reside on the property. After evidentiary hearings, the hearing officer has recommended that the board deny her application this time as well. The hearing officer stated that Ms. Chen had used the board's previous denial based on insufficient evidence of her claimed residency as a roadmap, and she'd offered evidence to address each shortcoming. The newly offered evidence, however, are often inconsistent with Ms. Chen's own testimony in the hearings for her applications. In the last application, the hearing officer and the board remarked on the significantly lower electricity and gas usage during Ms. Chen's alleged occupancy compared to that of her son, and the comparison was 40 kilowatt hours of electricity per month. It was 140 kilowatt versus 40 for her. This time, even though Ms. Chen testified that nothing has changed about her schedule, habits, or occupancy of the unit, her electricity usage catapulted in March and April of 2017 and also in May of 2017 to 150 for March and April and 118 in May. It so happens that in order to qualify for the current exemption, she must at least prove her occupancy since March of 2017. Mr. Gross accused Ms. Chen of leaving the lights on and the appliances on to run up her usage at his testimony in the hearing. He submitted photos to show that she left her porch lights on during the day and the lights on at night, even though she was not home. Ms. Chen attributed the dramatic increase in electricity usage from 40 to 150 kilowatt hours as being because of a new computer and television. Yet Ms. Chen also testified that she's rarely home during the work week, and the usage of computer and TV during those limited hours would not seem to account for a 300 to 500% spike in electricity usage. The same occurs with her gas usage. In the previous application, she averaged about 3 to 4 therms of gas, and now it's about 22 to 37 therms per month. Ms. Chen attributes this to cold winter months and a new gas dryer in the laundry. But her new gas average is the same in January as it is in May, and the use of a dryer would not seem to account for that dramatic spike. In the last application, the hearing officer noted that Ms. Chen received mail at the 18th Street condo, which she used to own, even though it was rented to tenants. Several days after the hearing officer's recommendation was issued in that application, she filed a change of address with the post office to the property that's before you. The hearing officer in this case queried why she had not changed her address sooner, and she responded that she didn't really get that much mail. Yet the hearing officer found that she has submitted a large volume of mail in both applications that contradict that claim. Her conclusion is reasonable in light of the facts in the record. Ms. Chen testified that on the advice of her attorney, she took photos of herself in her apartment every day of the relevant time period for her current application to document her presence in the unit. She submitted 338 pages of these photos. The photos aren't date or time stamped, but she testified that she emailed each photo to her attorney after having taken them so that the date and time of the email document the date and time of the photo. She said that she took 90% of the photos herself. The hearing officer noted that the photos, particularly the ones in the morning that are to capture her waking up in the apartment, appear overly dramatized. To take the photos, she testified that she had to get up, set up the phone, and then pose for the photo. Yet she appears barely awake in many of these photos. Her eyes are often half shut. At times, she's lying horizontally under the blanket, or her arms are in exaggerated stretching poses that are meant to convey sleepiness. As a result, the hearing officer found that the photos seemed disingenuous, and she accorded them little probative value, particularly since they were not date or time stamped. Her conclusion appears reasonable in light of the facts presented. Ms. Chen bears the burden of showing that she has occupied her unit as her principal residence. The inconsistencies in her evidence and the implausibility of her explanation prevent her from meeting that burden. To qualify for the exemption, she must also show that she has occupied her unit as her principal residence in good faith. This requirement in the board's regulation makes relevant her reason for occupying the unit. The fact that Ms. Chen filed her exemption application last year, the day after the hearing officer granted a decrease to Mr. Gross, and this time, again, as soon as possible after Mr. Gross filed his construction decrease petition, raises serious questions as to her good faith. The construction itself raises additional questions as to her motive in occupying the apartment. She had been living in her friend's spacious condo in West LA, where she had the entire bottom floor to herself. And instead of waiting for the remodeling and enlargement of her Montana apartment to be completed before she moved in, as her son had said she was going to do, she instead claimed to have moved in last summer. That meant that she moved into a much smaller 450 square foot apartment during construction to remodel the unit and the garage below. Ms. Chen said that she's not home during construction hours, so that wouldn't affect her. Her contractor testified that the construction would not impact her unit until the last phase. Nevertheless, there will be impacts from the construction next door and underneath her unit, and the hearing officer inferred Ms. Chen's lacked good faith given her decision to hasten her move-in to a smaller unit while the property is undergoing construction, file an application for exemption the day after Mr. Gross received his initial rent decrease, and then file the current application as soon as possible after Mr. Gross filed his new rent decrease petition. The hearing officer's inferences are reasonable and supported by the record. Staff therefore recommends that the board affirm the hearing officer's recommendation and deny Ms. Chen's application.
Thank you very much. There are 3 requests to speak. Before I get to those, I want to ask my fellow commissioners if you have any questions at this time about the staff report. Okay. Commissioner Foster, any questions?
It's for discussion.
Okay, very good. In that case, I have a request to speak. Rosario Perry, who I understand is representing the applicant's Chao Chen. I also have a request to speak from Chao Chen. So in that instance, they have a combined total of 5 minutes in which they can share the podium. I don't know how they want to do that. I'll leave that up to them. Mr. Perry, do you want to go first?
Please. We're going to, is it on? Yes. Okay, hold on.
Okay, I also understand you have a video or something to put up.
These are just the photos that were introduced
Okay.
at the hearing.
All right, Mr.
All right, so let me
Whenever you're
start.
ready.
Okay, thank you, Rosario Perry. I'm 312 Pico. You have before you the hearing officer recommendation, my objections, which is 10 pages, and the staff report. I was a little disappointed in the staff report because usually when I write my objections, they pinpoint where I'm wrong, and my objections this time didn't talk about my objections at all. But let me bring out what I think are the major points of discrepancy between the hearing officer and the actual facts. And I'm going to try to be quick. First of all, the photos. I think the photos are really very important, and you can see them either way. So the hearing officer said we submitted 300 pages of photos. It's actually about 600 photos. It's 4 photos approximately a day. So in the morning, Ms. Chen gets up, she takes a photo of herself. You can see one here as an example. This is the one that the hearing officer looked at from the actual iPhone Ms. Chen had at the hearing. You see she's waking up. She's mugging for the photo. I don't really think you look, that it means anything. The idea of the photo was to place her in the apartment in the morning. You'll see that the photo was emailed to me like 6 o'clock, 6:21 a.m. It was emailed to me at 6:21 a.m. Now, you see her leaving the apartment, that's probably about a half hour later. And that's emailed to me the same time. So those 2 photos come in one email. I gave the hearing officer a screenshot of my computer that showed all the emails coming in and saved. And all the emails match up. So if you look at those photos on my computer, which she could do because I gave her a disk, you'd see they arrived just about the time they were sent by Ms. Chen. Now, the tenant said she took them all at the same time. She just dummied them up, and then every day she emailed them because she wasn't really there when she emailed them. That's about 600 photos. Let's say it takes 2 to 3 minutes to change clothes and everything else to do a stage a photo. You're talking about maybe, I think I computed it to be approximately, it's about 30 hours. So if she literally staged these photos, it would have been 30 hours worth of her time. She gave the board, the hearing officer, a schedule of her work hours, and so the hearing officer knows exactly when she leaves the house and when she gets to work, and when she leaves work and goes to the gym. She gave her the gym schedule as well. And we can track Ms. Chen throughout the 120 days by the minute. Okay? Now, let me show you the next photo. This is a typical photo. Let me just put two together. This is a typical photo. You see she takes a picture of her car when she comes home. That's the tenant said he was always looking for her car, but he didn't even know the color of her car. He said it was brown. It's clearly blue. And then you see her walking in the door. So all these photos are staged to the extent that she puts the camera down and she takes a picture of herself doing the activity. But the photo is not to prove that she's been caught instantaneously. The photo is to prove she's in the apartment at the time of the photo. Now this is the very important part. The hearing officer looked at this photo on the phone, and it did have the timestamp on it. Every photo on the phone has the timestamp. The day it's sent, the time it's sent, even the location from where it's sent from. It says Montana, and it shows because it's an iPhone, it has a rough GPS. So the hearing officer is holding a phone with all the photos taken, and all she has to do, if she wants to know, she can look at each photo to see the time it was taken. She didn't record the time this was taken, but she should have, because it's instrumental to show that the photo was taken just a few minutes or maybe 15 minutes before it was mailed. So every photo is time-stamped. And the hearing officer didn't want to see that. She had the phone in her hand. My client said, look through all the photos you want and see and check the veracity. So she didn't do it. Why? Well, I just don't, I think they're trying to get to a conclusion. And, you know, for instance, well, so those are the photos. Now, where does she live if she doesn't live here? Well, the hearing officer says she lives in this luxurious bottom floor of this condominium on Stone Canyon. All right, here's the photo of the luxurious condominium. Wait a minute, this is it right here. That is the bottom floor of a bedroom. That's the only bedroom on the bottom floor. It's a bookshelf, there's a little cot, there's a little bed, and if you walk out that door, you see the laundry, and if you walk a little farther, you see the car. It's right off the garage. I mean, it's like a small little dungeon room. Why would she want to live there on Stone and work where she's working in Santa Monica on Wilshire when she could live in a beautiful 450 square foot second floor apartment? Why does she want to keep that apartment empty and live in this little crappy room with a bed? I mean, it's like insane. That's a crazy thing. I think I took my client's time. I'm sorry. Okay.
Thank you, Mr.
Thank
Perry.
you very much.
Okay. All right. So go ahead, Ms. Commissioner Phyllis. Questions for Mr. Perry?
So, Mr. Perry, obviously, if like the metadata for these photos was available, why didn't you submit it?
Well, okay, good point. I submitted the photos that were emailed, never dreaming anyone would doubt that. At the hearing, the photos were there, and if the hearing officer had a doubt about the authenticity of these photos or the time they were taken, she has it right there. I think she should satisfy herself of the time the photos were taken.
So you know that we are sitting not as an appellate body, but we're sitting as we're hearing this as a issue, I guess, of first impression. So I would like to. Does she have the phone with her today, and can we look at the metadata?
Ms. Chen, do you have? Yeah. Okay, she has it.
I want to see it too. Yeah.
Well, we can give you days. I'll give them all. You just pan through them.
Yeah, please.
Yeah. These are starting. Well, they start March 1st. Can I? Who should I hand this to?
Please.
So be careful because if you jiggle it, you lose the. But you'll see.
I'm pretty tech savvy.
Yeah. Just if you push on any photo, you'll see the time, and you'll see the metadata shows where it was from, Montana.
Okay. So I want to go back. So what's the statutory period that we're looking back to?
March 7th through 20 days, 120 days from March 7th.
from March 7th.
Would the rest of the board entertain the notion of trusting Commissioner Phyllis's observation of the metadata, or do we need to pass the phone down the whole dais?
I want to see the phone.
There you go.
Every other one, perhaps.
Okay, so this isn't showing me the meta. I mean, it's not. I know how to do that on my phone, and it doesn't look.
There's a little eye on the, you should be on the photo you can push, and that should show you metadata.
Yeah, I do know iPhones.
While you're doing that, I have some questions.
I'm just going to try to see if I can figure this out. And Mr. Perry, I'll come down and ask if I can't.
All right.
Okay, hold on.
Give her a second.
That's fine.
Yeah, I'm just going to look to see how to do it. All photos. All right, so I want to see, mine looks like this. Hers looks very different. It looks like it's in some sort of folder. So can you show, I need to see the date on each photo.
Well, it shows the date right there on the photo.
It shows when they were sent. It doesn't show.
No, that's the date of time. That's the time it's taken. Do you see it?
It doesn't look the same as mine.
All right,
Can I?
let me see if I can do it.
Why don't you go down?
I just don't want to change anything. Okay, so I'm gonna go back out.
I have questions.
Okay, well, hang on one second.
Go to my collections. Sorry, I'm sorry. Go through your.
Okay. She wants to see them.
I'll go back again. I'm sorry.
Yeah, like this.
North
Like this.
Montana,
Yes.
July 21st, and
Both of
the
them.
time come out already. 11 something. The time.
It's fine.
But that was what I wanted to see.
Yeah,
That's what I
yeah.
wanted
Each
to
one
see.
has the time, day, place,
Okay, so then I want to go
and
back to. I want to look at all of them. So, but see, it doesn't. Yeah, and look at it. Sees all of the photos. It just
Yes.
goes back to August. So I'm not quite sure.
yeah, because it,
Next year, we'll be implementing instant replay
Yes, see, it doesn't.
and challenge flags.
It doesn't show the stamp. So if you go to these ones, just click on one of the ones in July or March. Yeah.
okay, now back, yeah.
But if you go to one of these ones in March,
March, hold on, that's June.
it's going back.
All I get a lot.
I just want to click.
Here's one here. This one. She's
Okay.
leaving the door.
Ford, is it my turn to speak? They've had their
Oh, it
problem.
does.
I can solve
Okay.
this problem in about 2 seconds.
Okay, so I'll pass this down.
No, from the speaker in the audience, we're asking questions, so it doesn't count towards the 5-minute limit. Okay.
It has timestamps on it, on the date of each one. I mean, I haven't been able to go through each one, but
All right. So,
While we do that.
Commissioner Phyllis, while you're looking at those pictures, will you give up the floor so that we can have Commissioner Terosas ask questions in the meantime, or do you have more questions you want to ask?
no, that was my main question.
Okay. Thank you. Commissioner Terosas, go ahead.
Thank you. I just wanted to hear from Mr. Perry and also probably your client. Is there an explanation as to why the photos are in non-chronologic numeric order? Because I did look through the photos and they are in all different numbers.
Here's what happened. Yes, and the hearing officer made a comment on this. My client was taking those photos in, not flash. What is it?
Blast. Okay.
Blast.
I,
And so she put her thumb on the photo to take it, and like 5 or 10 photos would be taken.
And it is consistent with
okay. I'll look at that because
Yeah.
some of the dates that are subsequent dates have prior numbers on them in the file, which was just a little bit odd. I found.
And so, well, I'm not sure about that, but what happened was they're not sequentially in order because she was doing, it's called blast.
The blast-
It's not-
yeah, no,
it's
I understand
blast,
how that
yeah.
works.
It's not called blast, it's called something else.
Okay. Burst.
Burst.
Thank you.
Thanks very much. It's called burst, and so she was doing burst, and she got all kinds of, she got like 15 photos of the same one.
Okay. Are you familiar with the best evidence rule?
Yeah.
Is there a reason why the chain of custody for the photos wasn't submitted. I mean, I think there's a lot of questions that I have about how these could have been doctored from the time she took the photo to what we're seeing today.
Well, I think they were it was pretty solid. She took the photos with her own phone. She emailed them to me each, like maybe a half hour after she took them, she emailed them to me. So I have the same exact photo she has
Right,
on her phone
right.
on my computer.
I understand.
So I brought my computer and all the documents on my computer, which were the photos in PDF, on a CD and gave them to the hearing officer.
Right, but ostensibly, if one were to look at a reasonable doubt, you know, I could go to my house and take 500 photos and then day by day email them to you.
This is the crazy thing, because you'd be emailing them from your home 4 times a day. So what it means is she's living somewhere else, maybe in the basement at Stoner. She goes to the apartment at 6 in the morning and emails 2, comes back to the apartment in the evening, emails me 2, and then she goes home to Stoner in the basement again. I mean, it's insane. Why would someone do that?
Does she not work in Santa Monica?
She does work in Santa Monica. She works much closer to her home on Montana than the Stoner condominium. The Stoner condominium is in West LA.
Okay, and then how do you respond to the tenant's allegations that Ms. Chen's living activities have not changed substantially since the first exemption application, which was denied?
Okay. I'm not sure what that meant, but we proved that she goes to, checks in at her work in the morning and she checks out at night, and then she goes right to the gym, and we have gym records, and then she comes home from the gym or she goes to church. So we proved all that. In fact, we have the neighbor, if you remember, who did the calendar.
Yeah, I do.
And she says she's there she sees her every day almost on the calendar.
Mm-hmm.
So I know the hearing. I know that anytime there's testimony, your memory sort of follows your pocketbook. And we were criticized greatly as owners because we were trying to somehow skirt the rent board and get rid of the regulations. And that was a financial incentive for us to do something wrong. Well, it goes both ways. The tenant has a financial incentive to keep us from losing the exemption because the rent might go up somewhat.
I understand.
But that's really the answer. And now don't forget, the other tenant didn't even testify.
Okay, those are all my questions for you right now.
Okay, thank you, Commissioner Trosis. Commissioner Phyllis, did you have any other questions? You're next in the queue. Okay, thank you. And Commissioner Flora, you had questions for Mr. Perry?
No, just some general comments and some things that I'd love my colleagues to consider.
Okay, well, before we do that,
I'd like to hear from the other speakers.
Yeah, we also have the
so I can certainly wait.
Thank you, Mr. Perry. All right, now I have Nicholas Gross. You requested 3 minutes.
Yes, thank you. Good evening, esteemed board. I know you have the pictures, the staff pictures. If you look at picture 16, you look at page 10 of the actual hearing officer's recommendation. She talks about a security system that Mr. Roland Chen bought his mother. There are pictures also that were submitted of security cameras around Ms. Chen's front door. There's no question about doctoring pictures and staging pictures. That's already been established for the board. But she has a security system there, 24/7. If she was living there, all she would have to do is hand in DVDs to you guys, to staff, to the hearing officer. They'd have the date, the timestamp. She put in a security system, 24/7 surveillance. There's 3 cameras around her front entrance, yet there's no DVDs. If you look at picture 16, she testified that that is not a computer system. That is the monitor for her security system out in front. There's a DVD player right there. So we're talking about her credibility. This was also handed in, when we rented the place, she said it was 1,200 square feet. She said we'd have a fenced yard. She said we'd have in-house laundry. She said we'd have a fireplace. She said we'd have the cooling system. None of that exists. I'm just bringing this up because, as it turns out, we have less than 600 square feet, and she's charging us right now close to $3,400 at $6 a square foot, yet her own advertisement in Zillow and everything else says 1,200 square feet at $2 a square foot. Now, I want to go to...
Commissioners, I'm sorry to interrupt Mr. Gross, but I do want to remind him that it needs to be
I'm just
limited to what was actually
We're
submitted.
talking about her credibility in the pictures here. Now, I want to say this, that let's go to, I have to go to my phone now real quick. Okay, here it is. That was point one, the video surveillance. None of it was ever turned in, yet she has it fully operating. Point two, Roland Chen on page 23 said his mother was going to be moving in after the construction was done, right? Now, as we found out at the hearing, Ms. Chen is now subject to earthquake retrofitting on this unit. She's going to have to destroy the garage unit anyways. Ms. Pineda told her to do it while this ongoing construction was going on. The bottom line is there's no good faith from this woman. She has no concern for her tenants. We ask her to fix things. We ask her manager to fix things. They never fix things. She has no good faith talking to you guys. She makes staff and everybody here do literally thousands of pages of paperwork. Like I told you, going through 600, 700 pictures, she could have easily just handed you guys a couple DVDs. Their stamp, their time set. She has this operating security system, yet she didn't turn it in. Instead, as the hearing officer said, she staged the pictures. There's no concern making everybody do this work again and again and again. If she was living there, if she was living in a beautiful place for 6 months after construction, we wouldn't be here tonight. The point is, it's a total construction zone with tractors and dirt and filth. It's not habitable in any way, shape, or form. It hasn't been for the last 2 years. And Ms. Pineda said that it's going to be this way for the next 2 or 3 years. She's basically doing this to get out of a construction decrease.
Thank you, Mr. Gross. Your time is up.
Okay.
We have the phone. Ms. Chow. Oh, I'm sorry. Go ahead. Any questions for Mr. Gross? Okay. Thank you very much, Mr. Gross. You can have a seat. There are no more requests to speak on this item, so I would like to open this up for discussion. Commissioner Flora, you're up at first.
Yeah, I've been doing this for 7 years now, and I remember Mr. Gross from the last time we discussed this exemption, and I think he makes a fair point. Here's something I've never seen in 7 years. I've never seen such a production be necessary to prove a residency. Usually these exemption reports are, thanks to Amy and her department's good work, are very direct, a few pages long. The evidence is there on voter registration, on mail, on tenant witnessing. And yet for the second time in a year, we're dealing with an exemption that's 30 plus pages long, clouded in mystery, full of production value. This isn't normal. It just doesn't pass the smell test. And she may very well be a resident there, but I've never seen effort like this necessary to, it just reeks of desperation. And that's all I have to say. I'm very open-minded to what my colleagues have to say.
Thank you, Commissioner Flora. Commissioner Foster.
I would echo many of the sentiments of Commissioner Flora. I too am amazed at the amount and volume of evidence presented by the applicant. However, I too, in almost 2 years of sitting on this dais, have granted dozens upon dozens of owner occupancy exemptions. All of them met the letter of the law in a clear and straightforward fashion. And as Commissioner Flora pointed out, were fairly easy to prove. And it's hard to prove a negative. And I do respect the effort that the applicant put forward. And someday, in fact, this may transpire if the absolute rule of law is met and the evidence is presented in a straightforward and clear fashion. I am still not convinced regarding the timing and the machinations surrounding the various applications that this is in good faith, and that's where I stand on the issue.
Thank you, Commissioner Foster. Commissioner Phyllis.
So I'm still looking at this phone because I have looked at the photos. I looked at the email timestamps. I also looked at the timestamps in the phone. And honestly, I mean, unless there's a massive fraud being put forth against this board, like these photos are timestamped consecutively. We have someone who had a burden to prove that they were living there. She had an application be denied. It's not unreasonable that she takes, you know, kind of very careful steps to document where she is. And, you know, I'm combing through, you know, look, is it normal to take photos of yourself every single day to demonstrate where you're living? No, but also you're not trying to demonstrate after you've already been denied an application that you're qualified for this exemption. I mean, I don't think that we can impute nefarious intent just based on the fact that she's trying to document that she lives there. And I mean, if she did doctor these photos, shows massive intent of fraud, I mean, it would be egregious. It would be absolutely egregious. It would be something I've never seen before in my life. And I'm combing through these right now to see if there's anything I can see that would suggest, you know, this is someone who has just resaved them in their phone every single day. This is someone who's wearing the exact same thing every single day. There's no change in weather. I mean, I'm really trying to go through everything, but like right now what I see are 4 months of time-stamped photos showing that someone was at this apartment. We see an increase in energy usage. I mean, I'm concerned that it would be an abuse of discretion just to say, well, this person, you know, was not had a unsupported application before, so now we don't trust her and we're going to deny it again. I mean, I'm really concerned about it, and I'm trying to get to the bottom of it, but I'm concerned.
Thank you, Commissioner Phyllis. Commissioner Trosis.
Just before I get started, staff, would you mind enlightening us on the good faith requirement in this case and what level we must find that at?
The law says only that a landlord must intend in good faith to occupy the unit as his or her principal residence. The law doesn't elaborate.
Has there been any case law interpreting what good faith means?
It just means that must really be her intent. It means what it's not a term of art. It's a
right. And I'm just trying to think through this. If your good faith is that you would like your tenant to leave the unit because you can potentially make more money with a exemption.
I don't think that has any bearing on good faith, because the question is not what does she hope will result from her living there. The question is, does she in good faith intend to live there?
Right.
That's what the good faith is directed toward.
Ms. Chen, wait, I'm not. Sorry, the phone just locked. Can you please come unlock your phone again? Right. I mean, I would echo Commissioner Phyllis. I mean, I was conflicted upon reading the staff report. We haven't found another residence that she potentially could be living at. I think there's a fair amount of doubt here on both sides. I think there are incentives on both sides to deny and grant, from the party's perspective, this application. And it also does bother me that we would be looking at her prior actions as part of her character in this action. I mean, I understand we can take the totality of circumstances, but I think the staff report relies heavily on the prior petitions. I too looked through the phone, and although I think that the poses in each picture are quite exaggerated, and I do agree with that element, there's no denying the fact that they are date and time stamped and location stamped. So unless you have a person who is driving to and from this unit at 10:30 at night, at 5 in the morning, getting into pajamas and taking pictures, which that's the biggest con of the century for 120 days. I'm a little concerned that we don't have a lot to go on here in order to deny the exemption. Although I found it curious that she was literally sleeping in her bed for 120 days straight. I have never been at my house and never slept in another bed for 120 days straight. That's a pretty long time not to stay over at someone's house or go anywhere, but they are 120 days straight on the phone here. So, yeah, I think I'm in agreement with Commissioner Phyllis, but if someone else has an enlightening comment, I'd be happy to hear it. Oh, one more question. Do we know what type of building permits that she pulled in order to renovate these units? What was the scope of the work?
That is not in the record.
Okay, thanks.
Okay, then I have, that was Commissioner Terosis. I have myself now. I am persuaded by the timestamp on the telephone, and I think it would have been an extraordinary effort to try and fake it for so long. So I am willing to entertain a motion if anyone. Oh, I see that Commissioner Phyllis wants to speak. Is there something else you'd like to add?
Yeah, it's just very
Okay.
brief. If we were to disregard this evidence, right, that we have timestamp, location stamp, selfies in the unit for 120 days, I think we'd have to have real evidence of fraud, right? Like, aside from the fact that it looks posed, which is not evidence of fraud, it's just like, okay, well, this is someone taking a selfie. I look posed too. Like, but that's not what we have. So I don't think that, unless staff can direct us to any other information that would suggest fraud or suggest non-occupancy, I'm persuaded. Staff.
Oh, okay, is there a question to staff?
Yeah,
Okay.
please.
No, other than what Mr. Mordezai read in the staff report, the staff does not have any evidence of fraud.
Okay.
I shouldn't say other than what, I don't mean to suggest that what was in the staff report is evidence of fraud. I mean, we have nothing to say other than what was in the staff report.
Okay. I'm going to return, unless anyone wants to see the...
No, okay.
Mr. Chair.
Commissioner Foster.
So I do understand what Commissioner Phyllis and Chair Duran and Commissioner Terosis are saying on the face of the photos. The photos do seem to be time-stamped and place-stamped. However, I'm still not convinced on this application. It doesn't mean that in the future, she may not absolutely intend and in good faith execute a residency at this address. I questioned our own staff after the very first application that was denied. I said, what do we do when we see evidence of perjury or fraud before our board? Are they sworn? Are they sworn at the hearings? I asked the staff, and they assured me that they are sworn and that they signed something saying that under penalty of perjury. And there were unequivocally facts that were not facts in her testimony from the first two applications. It's plain as the paper on our dais. So to say that character or a preponderance of the past actions on the same address don't affect my judgment, they do. And if I were entitled to perhaps $1,000 more per month per unit for an owner occupancy exemption decontrol of the remaining units, totaling a possible $20,000, $30,000 a year in extra income, I think I could drive 6 blocks from where I work each day and take a photo. And so I am not convinced on this application. If it becomes her intent on another application to reapply, my vote still stays the same at this point. Thank you.
I'll yield to Commissioner Flora because I've talked a lot.
Okay, thank you. Commissioner Flora.
Get ready for a whole new era of photo binder evidence from Mr. Perry and Mr. Jacobson's clients, because that's what this is inviting, when most cases are very clear and based on very traditional, very easy to prove evidence. We will probably be inviting binders of photos.
Well, okay. Commissioner Terosis, I'd like to comment on that in a moment. Go ahead, Commissioner Terosis. Sorry.
I think she had a high burden to prove. She did what she needed to do. I'm not saying that she did it for altruistic reasons. She's going to make more money. And that's the unfortunate truth of an owner occupancy exemption. But again, unless I saw some mechanism of fraud, which I did not, it would be really hard for me to deny this just based on what the law states. I mean, she sold her condo, she has her voter registration, she has all of her bills, she has pictures that show her living there. I mean, I can't, if the good faith requirement is the good faith requirement, I don't see, anything to point to another location that she could be living at. So although it's really unfortunate, as a matter of policy, I mean, just based on the facts and the law, I think I would have to go ahead and grant the owner occupancy exemption.
Okay, so I understand the sentiment of the feelings. However, I just would caution the board that we have to look at the record before us and not weigh our decision based on what could happen in the future, and what may happen we don't know. So with that, the chair would like to entertain a motion if one is willing to make it. Otherwise,
I'll move. Although I have one really super brief comment, I'll make a motion. Okay. So I think we need to be really careful when we are granting or denying these owner occupancy exemptions, because this isn't discretionary, right? Like, this is, do you meet the standard? We have no choice if you meet the standard. In this instance, we have an applicant who previously did not meet the standard. She demonstrated later, or she put on evidence later, that she would meet the standard. I mean, to withhold granting an exemption simply because someone, worst case scenario, perjured themselves in a prior application, I still don't think that demonstrates fraud here. And to suggest that we can't trust this evidence when it's time-stamped, date-stamped, and no one has put on any proof that she is literally defrauding this board, I think would be an abuse of discretion. And I think we have to, uphold the law, whether we like granting these exemptions or not. And one thing I would like to add is, to the extent that Ms. Chen does not live here, and it ultimately turns out she's living somewhere else, and down the line, the tenant feels like there's evidence of non-occupancy, can staff just give us a brief overview about what the process would be for challenging an owner occupancy exemption?
Yes, an owner occupancy exemption expires by operation of law the moment that the qualifying factors cease to be true. So there's not a process by which the board revokes an exemption. It's self-revoking. Mm-hmm. So the question is only whether it in fact expired by operation of law because the facts changed or they were never true in the first place, or what have you. So if a tenant informs the board of changed circumstances or some new evidence, staff contacts the owner and says, "This is what we've been told. What do you say?" The owner has the opportunity to respond. If the owner's response is dispositive one way or the other, in other words, if they say, "Yeah, that's true, I don't live there anymore," or they prove that they do, mm-hmm. then there's nothing further. If there's a challenge, then there is an investigatory process and a hearing, and there's a whole process for getting to a determination of the underlying facts of, does the person live there or not, and as of what date did they cease to live there.
Okay. So to the extent that this is a concern, I want the public to know that we do have a process for investigating, and to the extent that, it looks like someone obtained an owner occupancy exemption to raise the rent and constructively evict someone and then drop it. I mean, that is something that we've never seen before, but I think would be enormously problematic.
It's because she's doing a construction project right there.
All right, I'm sorry. We're having discussion up here. We're not taking comments from the public at this time.
And so we're limited to the record. I'm going to move that we grant the exemption.
Okay, there's been a motion to grant. Does anybody have a second?
Second.
Okay, there's been a first and a second to grant the applicant's motion. Any more discussion? Seeing none, take a roll call vote, please.
Commissioner Phyllis?
Yes.
Commissioner Flora?
No.
Commissioner Foster?
No.
Commissioner Duran?
Yes.
Commissioner Tarosis?
Yes.
Motion carries.
Okay, moving on, thank you.
I have a motion about the next two.
Okay. We have item number 10A2 and 10A3. I am looking at my list for requests to speak, and having seen none in review of the two topics, at least in my mind, it appears that they have all met the threshold that they need to meet. I'm willing to entertain a motion.
I'll move to grant by consent.
Okay, motion to grant by consent. Is there a second?
Second.
Commissioners, if I
had
could
my
just
name in
make
too.
one technical note on the application by Mr. Monroe and Ms. Vasilius. As noted in the staff report, Ms. Vasilius does not qualify because she is only 18% or something, right? So, so that your motion would reflect the fact that you're only granting as to Mr. Monroe in that specific application.
Yes, grant per staff's recommendation.
And second.
Okay, first and a second. Any discussion? Seeing none, we'll take a roll call vote.
Commissioner Foster,
Yes.
Commissioner Trosis.
Yes.
Commissioner Flora,
Yes.
Commissioner Phyllis.
Yes.
And Commissioner Duran.
Yes.
Motion carries.
Okay, now we are moving on to item number 2, administrative items. This is the study session on consideration of tenant protections and costs associated with the City of Santa Monica's mandatory seismic retrofit program. Go ahead and, if there's a staff report?
Yes.
Thank you.
There you go. All right. Tonight we're holding this informal study session, excuse me, to consider issues raised by the City Council's adoption of a seismic safety retrofit program. Specifically, stakeholders have asked the board to consider whether required retrofitting work will interfere with tenants' occupancy of controlled units, and to what degree, if any, owners should be permitted to offset their retrofitting costs by passing along a portion of these costs to their tenants in the form of increased rents. Before getting into the discussion of these issues and reviewing the controlled properties that will be affected, I wanted to provide some brief background. So,
It's the arrow, right?
recognizing that public safety is government's greatest responsibility, last March, the City Council adopted a comprehensive seismic safety retrofit program ordinance to increase the safety of earthquake-vulnerable buildings. The Building and Safety Division has identified nearly 2,000 commercial and multifamily residential buildings that need to be evaluated for possible structural improvement. The list is available on the city's website for searching and download. Beginning in August, the Building and Safety Division started a year-long process of notifying affected building property owners about the retrofitting requirements, compliance deadlines, and appeal procedures. To help inform affected owners and tenants about the retrofitting program, the city will hold 4 seismic retrofit information centers, with the first scheduled for the evening of November 13th. The session will include presentations from Building and Safety about the program, timelines, and required tenant protections. A representative of the State Structural Engineers Association will provide information to assist owners with considerations regarding selection of engineers and contractors, and a rent control staff member will explain the board's current rent increase program and explain that the board is currently considering the cost pass-through issue. Oops. The seismic retrofit program includes established timelines for reaching 2 major milestones in the process. Because most of the controlled properties that are affected are soft-story buildings, and those are buildings with a ground floor that includes parking or similar open floor space below 1 or more stories of apartments. I'm going to focus on that timeline. Owners of soft-story structures who were sent notices on September 25th will have 2 years to submit a structural evaluation of their property to Building and Safety. If it's determined that retrofitting work will be required, the owner will have an additional 4 years, or until October of 2023, to complete the retrofitting work. Timelines are different for other types of buildings, as shown on this noticing schedule that was prepared by Building and Safety. Of the properties identified for evaluation, approximately 1,300 are controlled properties. As this chart shows, 1,272 72 properties containing almost 11,000 units are soft-story buildings. There are also 12 controlled buildings of other types. It's important to recognize that the list of properties is somewhat dynamic. For example, owners of several of the unreinforced masonry buildings that have received notices in August have already submitted proof to Building and Safety that the buildings were retrofitted following the 1994 earthquake. Upon verification, these properties will be removed from the list. This may also be the case for a number of soft-story structures, as many were retrofitted following the 1994 earthquake and may already meet the standards established by the Seismic Retrofit Ordinance. Like all programs of this magnitude, different bodies are called upon to address different aspects. The City Council, with its responsibility for ensuring public safety in the community, adopted the ordinance and stated that protection of tenants and the stock of existing housing in the city are of paramount importance. Thus, they included in the ordinance some enhanced tenant protections. In 1999, the Council adopted Chapter 8.100 of the Municipal Code, Tenant Protection During Construction. Recent major construction and rehab projects in occupied buildings have identified some areas where the law could be strengthened, and the Council did so in March. The good thing about the seismic retrofit work is that in most cases it will be done exclusively in the outdoor common areas and will not require entry into individual units. But even so, there will be impacts on tenants, and the new provisions require a means and methods plan for all occupied buildings. An update to the means and method form will be put into use this month, and it will require the owner to provide a detailed timeline and description for the work, and using a list of potential impacts, the owner will need to identify what impacts will occur and what measures they will take to mitigate the impacts. The enhancements to the form will also assist Building and Safety in identifying whether the work will require a temporary relocation at any time during the process. Older buildings are likely to contain hazardous building materials such as asbestos and lead paint, which can be harmful if disturbed. Existing state law requires a building owner to abate the hazardous materials in accordance with procedures of the AQMD. The new provisions in the city's ordinance clarify that owners must ensure that all hazardous materials are properly handled during construction, provide that the city will actively monitor such handling, and allow the city to engage the services of qualified experts at the owner's expense to assist the city in evaluating the owner's compliance. Finally, the ordinance requires a building owner to provide monthly notices to tenants on construction progress for projects that take more than 30 days. A recent change clarifies that the building officer may require that the owner conduct meetings to allow tenant feedback about construction issues. Since 1990, the City Council has had an ordinance requiring temporary relocation benefits for tenants who are displaced if a unit becomes uninhabitable. Recent amendments now require an owner to pay temporary relocation benefits if the seismic work impacts tenant habitability. Additionally, the building officer will determine the length of the relocation based upon the condition, and if the length of time is exceeded, an investigation and enforcement action may be initiated. This will address situations in which an owner doesn't move expeditiously to resolve the issue that required the temporary relocation. As mentioned earlier, areas for consideration by the Rent Control Board include whether required retrofitting work will interfere with tenants' occupancy of their controlled units, and to what degree, if any, owners should be permitted to offset their retrofitting costs by passing along a portion of those costs to the tenants in the form of rent increases. Under the rent control law, the board has authority to adjust rents downward if an owner doesn't properly maintain a unit or building, or if an amenity or housing service included in the rent is taken away. While it's unlikely that the retrofitting work will result in a permanent loss of parking spaces or housing services, if it does, tenants may petition for a rent reduction through the board's rent decrease process. There will likely be some temporary impact on parking, and the city is exploring the possibility of providing parking permits for impacted tenants who live in areas with preferential parking zones. The board also has a regulation that provides for rent decreases for construction impacts. A Court of Appeal decision in a San Francisco case limits a rent control board's ability to grant rent reductions for necessary or mandated work like the seismic retrofit program. However, there are two exceptions, and that is if the work is not performed in a reasonable manner or if it is not completed in a reasonable time. The city plans to isolate permitted seismic retrofitting work from any other permitted work on the property. In that way, the board will be able to differentiate required retrofitting work from elective rehab or improvement work that would be eligible for rent reductions pursuant to Regulation 4400. The cost of seismic retrofit work is the issue currently at the center of the board's considerations regarding the retrofit program. The city has estimated the cost for a non-complex two-story, soft-story retrofit to range from $5,000 to $10,000 per unit. We've obtained some preliminary data from the Los Angeles and San Francisco rent stabilization programs for properties in which the work has been completed and a petition for pass-through of costs has been approved. While the samples are relatively small at this time, they show an average per unit cost in Los Angeles of about $6,000 and in San Francisco approximately $13,000. The ordinance in San Francisco applies when there are 5 or more units and there are 2 or more stories of apartments above the open floor space, so those buildings may be more complex to retrofit than the buildings in Los Angeles. Apart from the direct costs of retrofitting, there will be other financial considerations or consequences that will vary from owner to owner. They include things like potential insurance premium reductions of up to 20% for owners who hold earthquake insurance, reduced repair costs for a retrofitted building following an earthquake, and possible impacts on income taxes. To understand the universe of properties and units subject to the program, the agency has analyzed the 1,272 soft-story buildings by a number of factors. The first thing we took a look at is when the tenancies began in the units on these properties. For this analysis, we divided the universe into 4 categories. We found that 29% of the units are occupied by long-term tenants, or people who moved in before 1999. 16% are occupied by what we're calling midterm tenants, and those are people who moved in between 1999 and the end of 2008. So that was in the early years of the Costa-Hawkins period. And more than half of the units, or 54%, are occupied by recent tenants, and those are people who moved in since the beginning of 2009. There's also a small 1% of the units that have no registered rents, and they are primarily units that are owner-occupied or have not been rented since 1978. The next thing we looked at was the median monthly rent levels by number of bedrooms for tenancies established in the 3 different time periods. As this chart shows, median rents for long-term tenants are between $735 and $1,292. For midterm tenants, the rents are between $1,101 and $2,668. And for recent tenants, the rents range between $1,479 and $3,169. As you can see, recent tenants are paying between $378 to $501 more than midterm tenants, and between $744 and $1,877 more than long-term tenants. We also took, the board often hears that many owners have not benefited from Costa-Hawkins and the ability to establish market rate rents. So we also took a look at the time period in which current tenancies were initiated for this universe of properties. For each category of tenancy, long-term, medium-term, and recent, the chart provides the number of properties and percent of the total group that have all units, half or more of the units, less than half of the units, or none of the units rented within that time period. What we found is that just 3% of the properties, or 43, have all tenancies established before 1999, while 1/5 of the properties have no remaining long-term tenancies. 62% of the properties have half or more of the units occupied by recent tenants, and in 11% of the properties, there are no units occupied by tenants who moved in since 2009. And this information all comes from the registration forms that owners are required to file after establishing a new tenancy. So absent any action by the board to adopt some form of direct pass-through, the board's existing net operating income increase petition process would be available to owners for whom the retrofitting costs resulted in the property no longer providing a fair return. In this process, current net operating income is compared to net operating income for the property 1 year before the rent control law was adopted. If the analysis finds that the owner is not making a fair return relative to the 1978 time period, reasonable and necessary costs may be passed through to tenants as permanent rent increases. We also took a look at what other cities with rent control are doing. So far, 3 cities, Los Angeles, San Francisco, and Berkeley, have adopted mandatory programs requiring evaluation and retrofitting of buildings vulnerable to damage in an earthquake. Each jurisdiction has adopted its own approach to handle retrofitting costs. This chart shows the terms of the direct pass-through programs in Los Angeles and San Francisco. In LA, 50% of the cost may be passed through with an amortization period of 10 years and a monthly cap of $38 per unit. In San Francisco, 100% of costs may be passed through with an amortization period of 20 years and a monthly cap of $30 or 10% of the current rent, whichever is greater, but only if the tenancy began at least 6 months before the retrofitting work was begun. To date, the average monthly rent increase resulting from retrofitting pass-throughs in Los Angeles has been $26 per unit, and in San Francisco, it's been $74. And those amounts vary a bit, and there's a chart attached to the staff report that has some additional information. Larger buildings perhaps have an economy of scale, so the cost is a little bit less per unit, and the pass-through also would be a little bit less. The pass-through period in both Los Angeles and San Francisco will be extended if the allowed pass-through cost has not been recouped by the end of the amortization period due to a cap, and the pass-through for a unit is eliminated if the owner resets the rent to market rate for a new tenancy. Rather than assume that owners would require a pass-through to maintain a fair return after completing the retrofit work, the Berkeley Rent Control Board chose to consider requests for rent increases for seismic work through an increase petition based upon a net operating income analysis.
Slide for Berkeley?
No, there's not a slide for Berkeley. Okay. So they're doing it based upon a net operating income analysis. Their retrofitting ordinance has been in effect since 2013, and they have received 1 petition, including retrofitting costs, and a decision has not yet been issued on that petition. So if the board chooses to develop a direct pass-through program, it will be necessary to consider the same factors that comprise the LA and San Francisco programs and are listed here. Additionally, the board could consider whether there should be any type of incentives. One possibility could be a higher pass-through percentage for owners who complete the retrofit work ahead of schedule and thus create a safer living situation for the tenants. This would be similar to the board's approach following the 1994 earthquake. Repair and retrofitting work that was completed by June of 1996 qualified for 100% pass-through, and retrofitting work completed after that time qualified for 50% pass-through. So, of course, as the board assesses whether to adopt a program in which property owners' retrofitting costs would be shared with tenants, it will be helpful to hear from as many stakeholders as possible. The board's public meetings and public hearings provide one method of obtaining feedback. However, with such a large number of properties and tenants impacted by the retrofitting requirement, the board may choose to reach out directly to the owners and occupants of the impacted units. That could be done through a direct mailing in which we solicit input or perhaps invite them to a specially scheduled board meeting on this topic. The board could hold a meeting perhaps on a Saturday when more people might be available to attend. So I'm sure both the public and the board members will have ideas about outreach efforts, which we'll hear this evening. So that completes the staff report. I'm happy to answer any questions. And before I turn it back to Chair Duran, I just want to thank Ms. Noseworthy. She did an extensive amount of work to create those two tables, and after all the hours that we spent, it was kind of like two tables, but there's a lot of information there. And she's the pivot table prowess. She's amazing, so I want to thank her for all her help. So that completes the staff report.
Thank you very much. And now I'm going to open this to, well, no, we'll do public comment. Yeah, we'll do public comment first. The first request to speak is Margaret Gentry. Come on up. You've asked for 3 minutes. And then just to kind of line up a few behind you, there's J.L. Jacobson, who's requested 3 minutes, and Bill Dawson, who has requested 2 minutes. And I'll repeat the times as they approach. Ms. Gentry? Is there a Ms. Gentry here?
Yes, I'm sorry.
Okay. You can come up and speak at the podium now.
That's okay.
Okay, you're passing?
Yeah.
Okay, very good. Then moving on to Mr. Jacobson, you have requested 3 minutes. And behind him, we have Bill Dawson and Sonia Fox Sultan. So whenever you're ready, Mr. Jacobson.
J.L. Jacobson, 2917 Santa Monica Boulevard. Prior to statements made in the last case, I have never been before this board on an owner occupancy exemption. And that could be easily checked out by reviewing the minutes and the agenda items. So I had to rebut what was said about me earlier. But before any of you arrived, I went through approximately 200 rent increase petitions with previous boards. And at the time, I began doing them in 1983. The board was doing about 100 rent increase petitions a year. And by the time of the earthquake, they were down to about 80 petitions per year. And now they are so rare that when the board does its annual report, it doesn't even mention them, or it says one person filed and one person gave up. Now, a funny thing happened after the time of the Northridge earthquake. I shouldn't say funny, it was pretty sad. Before the earthquake, capital improvements had useful lives, and the only useful life with 20 years was an elevator. That was the only one. And then after the earthquake, when they knew they were going to get flooded with increased petitions, all of a sudden there were 20-year amortizations all over the place, which means if an owner spends $20,000, they only get $1,000 of expenses. So even though your report is very accurate, it mentions that there were short-form improvements after the earthquake, and there were permanent pass-throughs, those people who got them had their costs divided over 20 years. And by the way, did anybody notice that there's no difference between dividing the cost by 20 years or taking half the cost, 50% of the cost, and dividing it over 10 years? I mean, basically, you're doing the same thing. But you should not be too confident about making owners go through the net operating income process, because you would be telling them that they have to rely on expenses that are 39 to 40 years old in order to get paid for earthquake requirements, because the old process was based on expenses in 1978. And although it's true that some of those expenses are stated on some of the registration forms, that's unreliable hearsay evidence and cannot be the basis of a finding of fact. So even though there's lots of old decision that says the rent increase process is wonderful, that's not really true in a situation where a city's mandating a bunch of requirements and the rent board is saying, yeah, if you want to get a rent increase, find your records from 39, 40 years ago and bring them on in. So I think you should be more reasonable like the last board was after the earthquake when they decided to give pass-throughs for improvements. I also mentioned that the, no, I won't mention anymore. I've done enough. Thank you. Bye.
Thank you, Mr. Jacobson. Mr. Bill Dawson, you have requested 2 minutes. Whenever you're ready.
Thank you, Commissioners. I wanted to applaud your efforts to have a public study session. I also wanted to thank Commissioner Phyllis and Commissioner Torosis. for coming to the public meeting last week. Very informative, and I hope you got something out of it. I manage a lot of property. I own property. I'm with Sullivan Deturi Company. We've gone through this before with the 94 earthquake. I helped supervise about 50 earthquake retrofits, so I've got a fair amount of experience on this. The suggestions I have for you to consider tonight, one is I'd like you to consider waiving the construction rent decrease for city mandated work, as staff called out. I'd also like to point out that the Building and Safety Department and code compliance are very in tune and very active and very capable of making sure to protect the tenants. There's the new position that was added there. I'd suggest that you adopt a similar pass-through process as the City of Los Angeles, 50% pass-through amortized over 10 years. The last thing I'd like to, or two things. I'd recommend that you include all of the cost, including any temporary relocation of the tenants that's mandated in the per diem payment. I don't think there's going to be that many that are going to be required to move out, but there might be some. And I think that that's a cost of doing the work, not just the construction and the engineering. So I suggest and recommend that that cost be included. The last thing I'd like to suggest is that you set up an appeal process. So when the work is finished and property owners come to you with all of their expenses, and then the staff comes up with a recommendation of the pass-through, if the owner doesn't agree with that cost and the pass-through, I suggest that you have a fair appeal process. And the same, it could be an appeal process for the tenants as well if they don't agree with it. So protecting the tenants as well as the owners. Thank you very much.
Mr. Dawson, I have a clarifying question by
Yes, sir.
Commissioner Foster.
Thank you. And actually, it's would staff clarify for the speaker on one of the points of their email, which I read before the meeting, that in fact decreases for construction rent are not applicable in city mandated work.
That's correct.
I appreciate that, and I appreciate the clarification.
You're welcome.
Yes.
Thank you.
Thank you.
I have Commissioner Flora. Did you have a question for Mr. Dawson?
I do, but not before I publicly, as I did privately, compliment Mr. Dawson on his LA Kings jacket. Go Kings, go.
Go Kings, go.
We'll have to
Another
work,
cup.
We'll have to work on Commissioner Tarosa's bill.
All right.
No, but in all seriousness, in your letter sent to us via email, you mentioned Mr. Vardani's guest column.
Yes.
He cites a report that found that owners could expect to save $7 in the future for every $1 spent now by avoiding or minimaxing.
Is that a typo?
Future major
Good at math,
repairs,
not-
it sounds good,
Yeah.
in the event of a major seismic event.
Yes.
Here's your following sentence. He's got a report. Simply put, money spent now on mandatory retrofitting does not increase the value of a property.
Yes.
He's got a report. What do you got?
My opinion, and that letter's my opinion. I did talk to staff at the Apartment Association, and the Caltech report is a cost analysis, cost-benefit analysis. And my interpretation and my opinion of that report is that in the event of a major seismic earthquake event, lots of damage, and the report pulls out, if you spend $1 now, you could save up to $7 later fixing major damage on it.
Right.
So that's a savings in the event of a major earthquake. But spending the money now, which we're mandated to, does not increase the value of our properties at this point in time. That was my point.
It just saves them.
In the event of an earthquake, yes.
Yeah, okay, thank you.
Thank you, sir.
Thank you, Mr. Dawson. Okay, I have now Sonia Fox Sultan, and if folks would be so kind, I have Fred Sutton behind her and Danielle Charney after that. Ms. Sutton, whenever you're ready.
Good evening, Board. I'm Sonia Sultan, Santa Monica resident, and I'm speaking tonight on behalf of Santa Monicans for Renters' Rights. The Santa Monicans for Renters' Rights SMERS Steering Committee voted unanimously to strongly recommend to the board that pass-throughs not be allowed, and that there should be no pass-through this time. We're in a completely different world post-Costa-Hawkins than we were after the '94 earthquake. At that time, rents were low, and as far as we knew, they were going to stay low. And so the income and the value of the property was necessarily limited by that fact. Now, post-Costa-Hawkins, as we can see from the charts that were presented by the staff, relatively few units are still at those low original rent control levels. It's about 70% have been vacancy decontrolled over the last years since Costa-Hawkins went into effect. And there's no doubt that these buildings have increased in value. The sales price, the sale value of the properties have gone sky high, and will continue to do so unless Costa-Hawkins is repealed, which we don't see that coming anytime soon. So we believe landlords are making much more than a fair return now, which of course they deserve, and that they, as was just discussed a minute ago, there is an increase in the value of properties when they're retrofitted. For one thing, when somebody sells their property and it's already been retrofitted, okay, that's a good selling point. Also, there could be a decrease in their insurance costs. I know when I did a seismic upgrade to my own home, we were able to get earthquake insurance, and for the first time. So that's a benefit. It also decreases the risk of the liability that an owner would face if they don't retrofit a building, and there's, God forbid, an earthquake and people are injured or possibly worse. So there are all kinds of benefits to the owner. And we believe that in this era, when rents are high and getting higher, landlords are able to do very well on the rents that are paid by their tenants, that it really would be not fair to expect that tenants would accept a pass-through. There are a number of other pass-throughs, and that's a completely different story. But when it comes to this new ordinance that mandates seismic retrofits, it should be paid by the landlords completely, and they shouldn't be allowed to pass any of that through to the tenants. Thank you.
Thank you very much. I have Fred Sutton, and then behind him Danielle Charney and Michael Millman.
Hello.
Mr. Sutton, go ahead.
Hello, Honorable Rent Control Board members. My name is Fred Sutton. I'm here on behalf of the Apartment Association of Greater Los Angeles, and we strive to uphold the highest standards in the rental housing industry throughout Los Angeles County. We applaud the city for undertaking the efforts to update these buildings as they're needed to protect the lives of the residents, and it's a discussion many cities are having throughout Southern California, and Santa Monica has been leading. As housing providers begin to work diligently on reviewing these properties, they have expressed their considerable concern as the costs, as they were mentioned, are anywhere between $5,000 and $10,000 per unit. Additionally, as other cities institute these mandates, the small pool of qualified engineers becomes ever more scarce. Recovering the costs on these enhancements will not only require considerable time, but the current structure of the annual increase places a considerable financial burden on the provider. As other cities have done this, and I've worked in these other cities, I've seen the difficulty that providers have had in financing these. Mostly, a lot of them are having to rely on their private finances because they're having difficulty obtaining loans. AGLA is currently working in the city of Los Angeles with HCID, the housing department, to obtain FEMA grants to help with the financing. Berkeley actually pioneered that, and I know they've already gone through a couple rounds of those. It's small, it's not a lot, but we're working to try to get that relief in Los Angeles. So I think another thing that's very important is housing providers find themselves in this position through no fault of their own. These buildings were built to the mandated code at the time, and we would respectfully request an allowable pass-through similar to other cities such as Los Angeles, and we urge you to consider that. I think you mentioned the parking permits is something that is already granted. We'd ask you to look at that as well. If parking is temporarily out of use, to grant permits for tenants to be able to park on the street. And in regards to that $7, I did also want to follow up because it was in our magazine, Apartment Age, that had that. Yeah, it's not a monetary gain. I mean, it is kind of an insurance for if the earthquake hits and your building has these issues. You can, if you don't have that, you will be saving $7 if your building is hurt in that earthquake. It is not money you're making off it and increasing the value of your property. Here to answer any questions. Worked a lot on it in the city of Los Angeles. Happy to answer any questions. Thank you.
I do. It looks like I do have a question, Commissioner Flora.
Yes, Mr. Sutton. I don't know if you've seen the report, but on page 12, there's an interesting table that talks about the fact that about 20% of the units in question have been purchased since 2010.
Mm-hmm.
Values probably pretty low, now pretty high.
Mm-hmm.
If it's no fault of my own, am I smart enough in 2010, 11, 12, 13 to consider the seismic state of a building before purchasing it? You know apartments. You're an apartment guy. Would it be pretty smart if I'm considering purchasing an apartment in, let's say, 2010 to consider the shape, age, and seismic shape of building?
I mean, doing your due diligence on any investment or property you're buying, absolutely.
Yeah. Okay. Thank you.
All right, Commissioner Trosas, questions?
Oh, I was curious to know about the FEMA grants that you mentioned that you're working on with HSID. If you wouldn't mind offline sending us further information about that process and how that's going. We will talk about it later, but it's not within the purview of the Rent Control Board to finance the projects, but I would definitely be interested in seeing the financial products you're putting together to forward that to our city council. Thanks.
And I don't know if you've looked at PACE loans or anything of that nature.
Yes.
But I'm just from experience, PACE, owners are not using it, but we want it as an option for people to be able to use it if the city hasn't already instituted that. Thank you.
Thank you very much.
Thanks.
Danielle Charney, and then Michael Millman, and then Denny Zane.
Hi. I think there are a whole bunch of different issues that I want to cover that are specifically just equitable. Whatever to me seems equitable seems right. If it's a landlord that's keeping low-income tenants and he's providing housing, he should get a break. If it's a low-income tenant, that $25 or $30 a month actually means a great deal, more than it's even fathomable for people who earn good money to even comprehend. So if we've got landlords that aren't selling out, aren't selling their properties, aren't making a lot of money, let's help them. If we have tenants that are already burdened, let's help them. Also, what's the cost if we don't? What's the cost of social services? What's the cost of all sorts of human services, medical services, first responder services, fire department, paramedics, and everything else? My dad worked disaster relief. Part of what he did was forensic anthropology. He ID'd dead bodies after massive disasters. He promised me, because he was part of a study here that was done ages ago, that when it hits here, it's going to be bad, and that the truth has been kept from us for 40 years of how bad. So he begged me to leave. So naturally, I never listened to him anyway, and I'm still here. But I think we need to, has anybody taken a look at what those potential costs can be and weighed those costs against what it would cost to help equitably across the board so that it's not really, no one's actually suffering, and should it hit us, everyone suffers less. there's all kinds of money that's going around for different things. Some of them, to me, seem less important than people not being crushed in buildings, that people not losing their livelihood if that's all they've got is that building, and that's their only income. People not losing the roof over their head or losing their legs or whatever it is. So, you know, to me that means more than some other stuff like buildings for daycare for employed people, new staff building. Things of that nature to me seem less important than the safety of the city, the human factor, and all of it. So I'm just saying, I think it just should be fair across the board, whatever that means, and an equitable line just drawn right through it so that everyone benefits, the whole city benefits. Because when it does hit, if it does hit, we're all nothing's gonna save us no matter how rich we are, where we live. We could be killed in a second, whatever can happen. So to me, it shouldn't take this long either. We should get it done. So.
Thank you very much, Ms. Charney. Next speaker is Michael Millman, and then behind him, Denny Zane.
Yes, good evening again. You know, I had some remarks prepared, but I was enlightened when someone reminded me that my best subject in law school was evidence, and I had enjoyed getting some good grades on best evidence and chain of custody. But that made me think a little bit about my trial work, where I've been pretty successful excluding testimony and evidence that's highly speculative without an evidentiary foundation. Let's give you a couple of those examples. Apartment owners are going to retrofit, and that means their buildings are going to increase substantially. That's known as an anecdotal opinion without a factual basis. Another opinion might be that earthquake insurance will be readily available after you fix the units up. Another wild statement without an evidentiary basis. I could go on and on about speculative statements. Leadership is why I came before this board. Yes, the apartment owners 6 years ago went to Washington, D.C. and went to FEMA hat in hand and said, can you give us some money? And Bill Dawson knows it. We were rejected. We went to Congress people who are friendly to apartment owners. Can you get us an appointment with FEMA? And they did, and it was rejected. We went to Sacramento, and Bill Dawson knows this, and we talked to legislators. Can you give us some money? Because we don't want to burden tenants. We went to the federal government, the state government, we went to Los Angeles, and we asked for money, and we were summarily rejected. No, I didn't sit on my derriere. I went first to others. Now I'm coming to you for leadership. It's easy to say the board has no jurisdiction over building and safety. Patricia Hoffman taught me there's ways to retrofit without using a $35,000 moment frame. You can strap, Bill knows that, and you can use shear walls. Your group should go to building and safety, and Rick Cole said, let's get flexible. My good friend Michael Soloff is sitting on $60 million of money, plus there was some bonds that were passed and some, I guess, some taxes on sales tax. Let's help rent burden tenants. They shouldn't have to pay. Let them get a voucher. You don't have the authority, but you can pass a resolution. You can go to the city council. You can plead the case. If there's a mom and pop out there, not Michael Millman, he didn't have to file bankruptcy, not Michael Millman's family, that don't have the money, let's go ahead and help them with a voucher from the city funds. By the way, the last time I looked at the recorded cases, earthquake was an act of God that wasn't covered with insurance. Thank you very much for your time.
Thank you, Mr.
Anybody
Millman.
have questions? No.
No questions pending. We have Denny Zane, and then we have Jay Johnson, and then Zeke Warsaw. Mr. Zane requested 3 minutes, whenever you're ready.
Yes, thank you very much, board members. Pleasure to be here. I too am here to represent Santa Monicans for renters' rights and to urge you not to approve a pass-through policy with respect to these earthquake retrofits. Yes, I think properly provided for pass-throughs in the '94 earthquake. But that was prior to Costa-Hawkins. Things have changed dramatically. We know that, in your own report, 86% of the buildings in the city have had more than half of their units go to market since Costa-Hawkins was approved. We also know that HUD data says that there are almost 7,000 renter households with less than 50% of the area median income paying more than 50% of their income for rent. Those are almost certainly the long-term tenants, and those are the people who will really bear the burden of this policy if there is a pass-through provided. We do not doubt that there may in fact be property owners who are burdened significantly and need help in the process of retrofitting. It should be a burden that the city helps to assume with them, not just the tenants, especially the most vulnerable tenants that are in their buildings. It should be a broader public policy and public resources brought to bear in the case of hardship demonstrated by a property owner, and we would urge that on the City Council. We also think that your policies of providing for an application when there's no fair return bolsters that argument. 7,000 households who are paying excessive rent and are very low income sounds like the opportunity for lots of new homelessness if you pass this through. That is not a policy you should adopt, I think, consciously. Instead, yes, you should go to the city. You should petition the city. But you should petition them to help property owners who need the help. We will be there with you. Thank you.
Thank you, Mr. Zane. I now have Jay Johnson and then Zeke Warsaw.
Good evening, Commissioners. Jay Johnson, 9th and Alta. I'm not here representing Santa Monica Consumers' Rights nor the Apartment Association of Greater Los Angeles, even though I'm a member of both of them. I'm here tonight representing myself as a property owner and as a past Rent Control Board Commissioner. We have a crisis. We have a crisis in this city. It's the earthquake which is coming. We don't know, of course, exactly when. It is a common enemy that we all have to really present a united front against. It is a shared responsibility. This organization, the Rent Control Board, is a quasi-judicial entity and with a primary purpose of preserving the existing housing stock in the city. It's one thing to regulate, but what is above that is the preservation of the existing housing in this city. That the proposal of the retrofit, of course, we all know is a mandatory requirement. It is proper public policy for the Rent Control Board to protect affordable and existing housing as a function of what this mandatory requirement is going to be. Therefore, I propose a 50-50% split of the costs, half for the tenants, half to the landlords, with a maximum of $38 a month, exactly what LA City is saying. Amortization period, 7 years. Short form for convenience and to encourage participation. A drop-off, which has been a criticism of what was done in '94, that it was a permanent increase. This should be a drop-off after the amortization period, and with the proviso that was said earlier about the total dollars. Fee waivers should be exempt. That would eliminate the problem that Denny just referred to about Section 8 people and people of very low income. All fee waivers would be exempt from the pass-through period. That you've already discussed the suspension of the decreased filings of the garage and parking spacing issues during construction. That's very important. Also, I come again asking for a preamble to Regulation 4400, which explicitly sets that, which was vague in the last time. The city or the landlord also can reimburse a tenant for a 1-year parking permit if there is a loss of parking. We must share responsibility. Lastly, I received a phone call last Tuesday from a broker saying 10-unit building from the seller who's afraid of all the retrofit factor, and this is one of the main reasons they were going to sell. Lastly, Commissioner Flores' previous comments about that study, that the value of the property is a function of the rental income multiplier, not on whether the retrofit was done or not. Even if you looked at a property in 2010, you're looking at the rental increase. You're looking at the rental total rental volume, rental amount and the multiplier thereof, rather than whether or not the retrofit was done. That is not a factor in whether you're going to buy the property or not. That the earthquake insurance is another misnomer. The California Earthquake Authority, CEA, only covers 4 units to a structure or less. With that, it's a 25% deductible of the value of the property, not of the damage that was caused. And the deductible is 10-20%. You're talking about $300-400 on those small buildings. It's $10,000 a year to do a policy on a 10-unit building, and it would make a big difference. I'll stop there. Thank you.
Thank you very much, Mr. Johnson. Of course. There is a question, it looks like, from Commissioner Phyllis. Mr. Johnson?
Yes.
No? Oh, okay. Never mind. Thank you very much. All right. I have Zeke Warsaw, and behind Mr. Warsaw I have Victor, it looks like Barbosa, and then Councilmember McCune.
Thank you, members of the board, for the opportunity. My name's Zeke Orson. I'm a retired Los Angeles Deputy County Assessor, and I've been both a tenant and a landlord. And I thought it was just important to come to a meeting like this to discuss the determinations for the cost allocations between landlords and tenants on the city's mandatory seismic reporting for the retrofit. And I understand this is really a difficult decision for the board to make, and it's complicated, and there isn't probably any one right answer, but you have to come up with a decision. So, of course, I think the most important thing in this whole discussion is public safety. That's the most critical issue. We don't want people getting injured or dying. And the landlords and the tenants will both benefit from the city's mandatory policy here. And I think in this respect, I believe that it would be fair to have the cost shared equally by both of these parties on a 50-50 basis, just like the city of Los Angeles did, because they both benefit from it. There are some tenants, obviously, who cannot afford any rent increases, as well as some landlords who can't afford the very high cost to retrofit. But I think the board has to come up with something that is really reasonable and equitable and fair. And I think, in my opinion, the equal sharing of that would be the best way to do it. And then, just as a former appraiser, and when somebody mentioned earlier the increase in value due to retrofitting, as a professional opinion, I probably have done 30,000 appraisals in my career, and a lot of them had to do with earthquakes and different policies and problems that they had with buildings over the years. And I think it's almost impossible for anybody alive to tell if somebody spent $100,000 today to retrofit their building, what percentage of that 100,000 would actually be attributable to how much increase in value of the property would occur. That would be determined afterwards. So when people start saying this as non-professionals who haven't been appraisers, everybody has an opinion of value. And that's all an appraiser is a person who has an opinion of value, but their opinion is based on experience and a lot of judgment. But it's, in my opinion, it's almost impossible right now for the board to tell that. So basically, good luck in your decision, and thank you for helping me.
Thank you very much. I have Victor Barbosa, and you have requested 1 minute. Mr. Barbosa? Behind Mr. Barbosa, we have Councilmember McCune and Lori Brown.
Yeah, hi, I'm Victor Barbosa, and just here, first time meeting ever come to a meeting. I'm just here to hope that you guys do fairness, and fairness is for the tenant and owner. That's all.
Thank
fairness?
you. Go ahead.
That's it.
Oh, okay. Thank you very much.
You don't want me to dance or something.
That's quite all right. Thank. I'm sure you're a great dancer, but thank you. Oh, there is one question, if you would, Mr. Barbosa. There's one question by Commissioner Trowsis.
I just have a question. You said fairness is the landlord and the tenant. What did you mean by that?
Well, to be fair, is to be fair for both sides. You just can't be one-sided.
Okay.
That's what I mean by fairness.
Thank you.
You're welcome.
Thank you very much.
I'll dance this one.
Okay, Commissioner McCone. Yes, I'm sorry, excuse me, Councilmember McCune.
You can call me Al. I think you all know me. For the record, my name is Kevin McKeown. I am a Santa Monica renter. I live right on top of the Santa Monica Fault. It's not my fault, it's our fault. I've been in that same apartment for almost 42 years. And due to the stability in housing that I get from rent control, it's been my privilege to be a Santa Monica council member since 1998 and to be a former mayor of the city of Santa Monica. But I'm not here for the city, and I'm not here speaking for the city council, although I did warn you we were handing you a hot potato with this one. I'm here as an individual, as a renter, and in fact, I'm a renter who has no personal skin in this game, because back after the Northridge earthquake in '94, I have a responsible landlord who did the seismic retrofit. So my building is already done. But I'm here for fairness for the renters who are in Santa Monica now, who are facing what could be a crippling rent increase. Back in '94, renters paid. I paid. I'm still paying, as a matter of fact, because there was no sunset on that. But I don't think you should go down the same path now. I've already written to you on the record, and you should have the email in your packet, as to why I think that retrofits, frankly, are a good investment for landlords, for property owners. The March edition of Apartment Age, which is the publication of the Apartment Association of Greater Los Angeles, said researchers at Caltech recently performed a general benefit cost analysis on several types of residential structures, including a soft-story apartment building. They found that for every dollar spent on retrofitting, owners could expect to save up to $7 in repairs. Now, is that an immediate increase in the worth of the building? Maybe not. But let's not talk about if there's an earthquake in Santa Monica, it's when. Okay, so that saving in repairs of $7 for every dollar spent is very real. There's more in the email that I sent, which I hope you've read, and actually landlords seem to understand that retrofits do benefit them. This week, I just got the October issue of that same Apartment Age magazine, and a Glendale landlord is quoted saying, "The retrofits protect my investment." So let's remember, it is the property owner whose property is protected by having had this retrofit done. You may hear tonight from a few small Santa Monica landlords who claim hardship nonetheless, and there may be some such cases. There may also be people who are concerned about being ripped off by unscrupulous contractors. Now, city staff and your staff are conducting community meetings with representatives from the Structural Engineers Association of Southern California to advise landlords on selecting a good contractor, as well as tenants' rights and the owner responsibilities. As for true hardship, new market rate rents are sky high, and they're going up. A report released yesterday from the USC Lusk Center for Real Estate and Beacon Economics predicts the average rents in LA County over the next 2 years are going to jump by $136 a month. So that's predictable income that would counter any cost of doing the retrofit. Your staff report points out that almost 4 or 5 buildings in Santa Monica are mostly post-Costa-Hawkins renters. It's only 3% that might have hardship, and frankly, I would be happy to engage in a conversation on how the city might provide lower no-cost loans for those very few cases. Thank you for your time.
Thank you very much. Commissioner Phillips, do you have any questions? Okay. Okay. And just to check, Commissioner Trowsis, questions? Okay. Commissioner Foster? Thank you so much. Now we have Lori Brown, and behind Lori, Jennifer Kennedy, and then Elaine Golden-Gieler.
I, like Kevin, don't have any skin in the game. Though I am an apartment owner and have been a renter, and as some of you know, I purchased the building a few years ago from an owner that was elderly, and it was time for them to pass the building on. I want you to understand that most of the landlords that you're talking about in our community are elderly. And the things that they're facing as small landlords, I think that you learned the other day when you came out that this severely affects them. I also want to point out that earthquake insurance was a question that was asked the other day at the meeting, and they asked how many people had earthquake insurance. Not very many hands went up. I can tell you why. Because it's very, very, very expensive. And it doesn't cover much. And there's a huge deductible. Huge. If an earthquake comes, whether the building is retrofitted or not, there's going to be lots of problems. Because I don't necessarily believe, I'm not a magician, but it's not a given that if you're going to retrofit the building, that the building's going to stand up. So again, when it was mentioned tonight that maybe the city will recommend some people to work as hiring people in the city, every time you say you're from Santa Monica, they charge us a lot more money. So we're faced with a lot of challenges that I don't think people are aware of. Also, when I called up, there wasn't a discount for if my building was retrofitted. And I don't believe that if I did any standard work, if I went to sell my building tomorrow, that would come into place. I think you learned tonight that it's a matter of how much the market, how much you can get for the building, how much your loan is, how much all the different numbers come in. And there's more expenses coming up than just the retrofitting. I have new tenants that it took me 6 months to get tenants into the units, and they want to move out because of the homeless situation. So now I'm faced today with building a fence. And I'm building a fence, and I don't know where the money's going to come from. And truthfully, if my building was having to be retrofitted, I'm out of business. I would be knocking on your door for money because I would not qualify for a loan. I would not qualify. The people in that room the other night said they would not qualify. Either they had to take it out, they're elderly people, they don't necessarily have large incomes coming in. I don't know where the money's going to come from. Also, I understand for those low-income tenants that are rent burdened, yes, I believe that there should be a subsidy. Where the subsidy comes from, that I can't tell you. I can tell you as a small business owner, I'm not making even what somebody might call a fair return. I'm just trying to maintain. The buildings are old. They have a lot of work that they need to do. It's constantly coming up. The fees are constant. As Tracy can tell you, many people get behind not even able to pay their fees to the Rent Control Board. Thank you.
Thank you, Commissioner Brown. I now have Jennifer Kennedy. You've requested 3 minutes.
Hi, I'll take a lot less than that. I'm Jennifer Kennedy, Santa Monica resident, speaking just as an individual, even though I'm currently a planning commissioner in Santa Monica, and I am a former Rent Control Board member. So just came tonight to support you, and actually to lend my support to renters throughout Santa Monica. I know that you guys have a great staff. You've heard a lot here this evening. Whether or not you decide to form a subcommittee, that's up to you. But you'll have all of the information that you need to make the right decision, and based on the information I have, I urge you to not pass these costs through to the tenants. In Santa Monica, renters have, even after Costa-Hawkins, the recontrol of rents provides stability to tenants, and a pass-through like this would add a layer of instability on top of that. And I think because rents are so high throughout the region, it would be a huge burden for tenants to have to face a pass-through for these retrofit costs. So I urge you not to do that. And again, thank you for the work that you're doing.
Thank you, Commissioner Kennedy. Elaine Golden-Gieler is the last request to speak. Pass? Okay. And just to circle back, Margaret Gentry passed earlier. Do you have a new interest in? Okay. Then that is it. We will close public comment and open to discussion. I have Commissioner Phyllis. Go ahead, Commissioner.
Thank you, Chair Duran. So I want to open up by saying that this conversation and the study session and the action that the board is going to take is long overdue. I think we are up against the clock in terms of facing the big one, and it's scary because we're behind. We know that there are 1,300 buildings that are vulnerable, And I'm really concerned about creating an incentive system that would facilitate retrofitting sooner. I think that the period, can staff remind me, please, the period of compliance, like the...
For the soft story buildings, they have 2 years from the time they receive the notice from Building and Safety to complete the structural evaluation. And then if retrofitting is required, an additional 4 years to complete the actual retrofitting.
Right, so we're
it's a
talking
6-year.
about like a 6-year period. I mean, like, we know that we're overdue for the big one. I mean, this is, and we've been talking about this since I ran in 2014. And that's not just on the back of the rent control board. You know, we're also talking with members of city council had to also address this. So this has been a staggered process. But now that it's in our hands, I care about creating structures that would facilitate expeditious retrofitting. I want to talk a little bit about an issue that I'm seeing tonight that hasn't come up, but that I don't think we talk about seismic retrofitting pass-throughs without talking about pass-throughs for other things generally. So I don't think we can talk about seismic retrofitting pass-throughs without talking about pass-throughs for bonds, without pass-throughs for taxes. Like, this has to be considered this has to be considered overall, and here's why. We've heard from multiple landlords, I mean, both tonight and in the previous meeting that we were at, that if the retrofitting process, which is now mandatory, is too onerous, they're going to sell their buildings, right? It doesn't even matter if they're Ellising, because we have heard month after month tenants come to the rent control board and say, these bonds that you're allowing to be passed through, which are based on property values, are creating enormous increases threefold what we're talking about in terms of a cap on the pass-throughs here. So, like, I want everyone in this audience to understand we're talking about a $30 pass-through cap, maybe, right? If we're talking about a 50% amortized over 10 years. But if we make it too difficult for landlords to pass this through, and a building just turns over, so we're not even talking Ellising, right? That building goes up in property value, it gets reassessed, the bonds for that building get reassessed, and that increase goes up. I mean, it can go up tenfold. It can be enormous. So we cannot talk about these seismic retrofitting pass-throughs without talking about the potential impacts on other pass-throughs as a whole, which are passed through 100% to the tenants, which is not consistent across the state. So this is a significant issue that I want staff to consider. Okay, so that said, there are things that I really care about here, which are obviously making sure that this is equitable across the board, okay? What does equitable mean? Some would say it's to each according to need. I think no matter what we do, there are tenants and landlords who should be protected. So who are those tenants? Absolutely 100% the tenants who are exempt from reg fees. But we also need to consider these tenants that Denny was talking about, who are severely rent burdened, who may not be exempt from reg fees. Those tenants who are long-term tenants who are at those extremely low rent ranges, the tenants who are on extremely fixed incomes. And I'm not talking about tenants who have extremely low rents, but also a lot of cash flow. I'm talking about people who are legitimately rent burdened. Those people should not be, if we consider a pass-through, should 100% be exempt from it, okay? But I also care about these landlords, right? Like, we have landlords who do have legitimate cash flow. I'm worried about people qualifying for loans. I'm worried about people being able to retrofit their buildings, because if they cannot, or if it is too difficult, they're going to sell, and the ramifications of them selling are even worse than if we had a 50% pass-through. And I welcome being disproven on that from staff, but really, if we're talking about buildings that have not turned over for 10 years, when they are reassessed, those bonds, which we have heard people in this audience support, are going to have more significant pass-throughs than what we're considering in terms of retrofitting. So, we need to be honest about what burdens tenants are facing with regard to these pass-throughs. What I would love to hear from council is more information on, okay, how are we going to make sure that this process results in the least turnover for buildings possible? So like, I love this idea that Councilmember McEwen raised, where if there is a demonstration of need, low cost loans, no interest loans, loans that allow landlords to keep their buildings, especially these mom and pop landlords, who I do believe there are several of them in Santa Monica, and those are the landlords that I care about keeping the buildings, because many of those landlords have great relationships with their tenants. Many of those landlords are helping to keep their tenants in place, and without good landlords, you can't have happy tenants. So I think we need to be sensitive. The other thing that I really want to talk about tonight, because I don't think we're coming to a final decision tonight, but I do think we need to by the end of 2017, because this is been way too drawn out of a process. And with these mandates coming up on these landlords, there needs to be some certainty for landlords on how they're going to get this process done. And I'm sorry, but there's only a limited number of contractors in the city of Santa Monica, or even in Los Angeles County, who are going to be able to do this work. And if we care about getting it done quickly, we need to give people certainty as to how they're going to be able to finance it, how they're going to be able to push it through. And I think that means, if that means we have to have double sessions for the next 2 months, I'm committed to doing that, because like, lives are at stake. We're overdue for the big one. And like, we need to take this seriously, because if it happens before then, it is on our backs. So that's it.
Thank you, Commissioner Phyllis. Commissioner Foster.
Thank you. And thank you, Commissioner Phyllis, for all of your truly heartfelt sentiments and concerns. I share all of them. I want to start with a couple of things for staff before I get into some of my thoughts on the matter. First of all, I'd like to direct staff to bring further detail of Berkeley's plan. Since they are the most like us in number of units and typical real estate values, as opposed to an economy of scale like San Francisco or Los Angeles. In other words, I'd like to know, we have 3% of buildings with potentially no market rate rents, for instance. I would imagine Los Angeles and San Francisco have substantially higher percentage of buildings in more economically depressed areas that are also, So I don't think LA and San Francisco are an apples to apples comparison. I'd like to ask staff to bring much more detailed information from Berkeley, because they've had 4 years already of administering a retrofit program in a community much more similar to ours. So I look forward to hearing more information about Berkeley. Am I wrong on the number of years?
No, their program has been in effect for 4 years. They have many fewer buildings of soft story construction because they have an older housing stock. They had a preservation program. So whereas in Santa Monica, a lot of these buildings were built at the same time, they don't have as large of a quantity.
Thank you. Well, that's exactly the kind of information for the next step. Not to be dealt with here tonight, but to have more information on.
The information that you would like would be similar information to what we provided for our housing stock, like of their soft story buildings.
Of their soft story buildings, yes,
okay.
and apples to apples.
I'll see whether that information is available from them.
Okay. Also, a question for staff. In 1994, after the Northridge earthquake, did the entire Los Angeles region, similar to what we're talking about now with the city of Los Angeles, city of West Hollywood, city of Santa Monica, imposing mandatory retrofit. After Northridge, there were also several jurisdictions that imposed retrofit demands on the building population. So in 1994, is it reasonable to assume that they faced many of the concerns that landlords face now, with regards to possible price gouging or possible scarcity of engineers and qualified repair outfits?
Yeah, I think that was definitely the case then, because there were a lot of damaged buildings after the Northridge earthquake. So the demand was great for contractors and the retrofitting work. Yes.
Thank you. And the reason I asked that question is because in reaction to some of the concerns I've seen through articles, Facebook, letters to us prior to the meeting, and some of Commissioner Phyllis's comments about burdens that landlords face or building owners face in facing down this task. It is a task. But I do feel that also in your staff report, you pointed out that over 1,000 landlords successfully tackled estimates, completed repair work with contractors, and completed the paperwork necessary to achieve the pass-throughs from their tenants. So 1,000+ landlords were savvy enough, many of which I would assume, some of which were corporate type landlords and some of which were mom and pop landlords. Would that be accurate?
Yes, that's accurate. And it was a kind of expedited administrative process that we did. So the owners would submit the proof of the work that was completed with the contractors' bills and proof that they had paid them. And so we went through an administrative process that allowed us to process those 1,000+ petitions. And the decisions were issued administratively, and then there was an appeal process to the board if either of the parties disagreed with the decisions.
Great, thank you. It's my hope that that because 1,000+ landlords successfully applied for a pass-through last time, meaning they completed the work, that I sincerely hope that the 1,600 buildings in question, that number turns out to be drastically lower than that. And I'm encouraged by the fact that 1,000 successfully completed retrofits after Northridge. Is that complete?
No, those were not all retrofits. Some of those 1,000 petitions were just repairs.
Were just repairs.
Right. The 60 that were done under Regulation 4113B, those were all retrofits with the 50% pass-through.
Okay. So between repairs, which requires a lot of contractors and a lot of estimates and a lot of sophisticated negotiations and dealings with contractors, there were over 1,000 successfully completed. Good. I'm encouraged that 2017 owners, with the advent of the internet at their fingertips and with the help of our city and of this agency, will be able to tackle it again. The other thing I'd like to point out, I will gladly be a part of any effort to bring to City Council strong support for price gouging prevention, for close work with associations of engineering and contracting firms that might be entertaining bidding on the work of Santa Monica landlords, that we do price gouging prevention and some analysis to help support landlords who may be in fear. I would also hope that AGLA and Action and California Apartment Association would aid their members in this effort. And we were assured at some community meetings that they will, and that they in fact already are. To Councilmember McEwen's point and Commissioner Phyllis's point, to the 3%, for instance, and I'm not limiting it to that by any stretch of the imagination, but the 3% of buildings in Santa Monica that don't have readily provable market rate tenants at all. First, I think we should verify with those tenants through a door knock, a letter writing, the same way our investigating team would contact, say, the other tenants in Mrs. Chen's building from earlier tonight. It's a small number of buildings, 40-some buildings, so I think we should contact and verify the rents and tenancies of those buildings. I think rather than waiting for an owner to discover that this is an issue or a problem for them, I think we should proactively contact the owners of those buildings, for starters, and we should advise them of the NOI petition process. We should advise them of whatever we can come up with in cooperation with the City Council. Proactively advise those landlords of any PACE programs, low interest loans, no interest loans, lists of qualified engineers and architects, and whatever the city council and the rent board perhaps together should come up with resources and a database and low interest or no interest loans. That is my personal wish. And I think we should approach the owners of those buildings who could potentially be rent burdened before they have to discover it on their own and then try to figure it out. So I think that could be very helpful to the truly most burdened landlords among the landlord population. So with that being said, the last point I want to make is that, and I've said this before from this dais, business owners have always, and are always, subject to regulations and rules of the jurisdictions in which they own their business. And I always use a shoe store. If you own a shoe store, you have a certain permits and fees and regulations in place for retail business. However, I don't like to hear landlords classify themselves as, well, this is just my side gig, or this is just a little side project. It's a business. They are business owners. And unlike a shoe store, it's more like a school bus company. They have chosen to own a business that houses human lives, which, much like a hospital or a school bus company or an automobile company, comes with an extra burden. You're housing human life. So while some of the letters that have been directed toward us do mention that perhaps the intent of retrofitting is definitely to preserve human life from tragic consequences, I do not feel that that's a disqualifying event for the responsibility of landlords to sustain their businesses. That being said, I do echo what Commissioner Phyllis said about not wanting to encourage people to sell their buildings, but my first duty is to preserve affordable housing in this community. So the tenants who are in place today would be rent burdened more than they already are by an onerous pass-through of an earthquake retrofit. At this point, and we are certainly not done with debate or discussion or hearing from the public or hearing from stakeholders, but at this point, I am not persuaded yet, and welcome much more information from our fellow jurisdictions around us and from council. I need to hear more details about what penalties are in place this time around that weren't in place last time around to encourage timely compliance. That was a major issue after '94, was that there was no enforcement of compliance with the retrofit. So to echo your concern about whether or not it'll be done or in a timely manner, there's also, in the staff report, it mentioned that council did provide for a clear, defined penalty structure. Do you know what that is?
Well, that's correct. If owners don't comply with the milestones that are established, they would open a code enforcement case, and there could be penalties associated with those violations.
Thank you. So, if an owner is housing low-income tenants and at low rents, if they are accepting willingly, which they should, Section 8 vouchers, if they can complete an NOI application that shows they are in need, I feel that we should have some remedy for those owners. Other than that, I do not feel that a pass-through is appropriate, and for the reasons everyone has already stated, several people have stated. Costa-Hawkins means that with your very next open unit, you can take some of your costs into account. And I think that if the city does its due diligence in finding and helping secure low interest or no interest loans or exemptions for truly burdened owners, that would satisfy me. And I am at this point not inclined toward a pass-through. But we are far from the end of this discussion, and I welcome the debate to come.
Thank you, Commissioner Foster. Commissioner Terosis.
Thank you. First of all, I just want to thank staff in fielding all of my many questions and putting together such thorough information. I also want to thank everyone from the public that spent multiple hours sitting here and waiting to comment, as well as people that sent us mail, email, online correspondence via Facebook. Anyone who has an opinion, thank you, and we appreciate it, and we hear you. And maybe we don't all agree all the time, but we're all here to do what's best for the community, and and thanks for coming. Before I get into my thoughts, and I do want to clarify, we are definitely not making any sort of decision on this tonight. I think this is a very serious decision to be made, and it's not one that any of us take lightly. I think we need quite a bit more information, and I personally need to hear from more members of the public, more members of the community, and so I just want to clarify, we will definitely not be making any decisions tonight. I wanted to direct staff to calendar a special weekend meeting of this body where we invite recognized community leaders to engage the board in a roundtable discussion of proposed solutions to the cost of retrofitting. I would like to dedicate a special meeting where people don't have to, spend till 10 o'clock on a school night to come, potentially, again, on the weekend. I would appreciate that. I would also direct staff to prepare a survey, and I personally think making that survey available on our website as well as by email, and I understand not everyone uses the internet, but I mean, it's 2017. I think that's the most effective way to reach the largest amount of people. If you could share a copy of that with us before sending it out, I would like to survey as many people as possible. I'd also like to hear more about a public outreach campaign to reach those who might not know that we're taking up this issue. I think obviously landlords have a financial interest in the outcome, a direct financial interest in the outcome, but I don't necessarily know that tenants know that this could affect them. And I really want to make sure that we're reaching out to tenants so that they can feel that they've been heard. I think the landlords seem to be mobilized, and I appreciate that, and I appreciate the dialogue. But I want to make sure that we're reaching the tenants, especially those that might have any sort of barriers, especially linguistic barriers to coming and weighing in with us. So with that being said, moving on to the issue before us with City Council. I know that we have just been tasked, and our jurisdiction is only to consider the amount, if any, to be passed through to tenants of rent control tenants of a potential retrofit. However, like Commissioner Phyllis, but for different reasons, I don't think that can be considered in a vacuum. I think part of coming up with a solution is looking at the totality of options, and those options include financing mechanisms to go along with the amount of money actually to be passed through. It's how quickly can we get the job done? How easy is it because time is money, for a landlord to make it through building and safety with all the plans that they need, and then how easy is it to finance these jobs? And so although that might not be within our purview, I really would like to explore us working with City Council, however that might be, if it's a special session with City, I don't know, I would look to our council as to how we could potentially work with City Council on this, other than just to send like a 5-signature letter, which could fall on deaf ears. I would like to be a little bit more proactive. But I think that we brought up the issue of consumer protection. It's something I know quite a bit about. I also know that an anti-price gouging ordinance would only go into effect if we had a state of emergency declared. And this is, I do not believe, a state of emergency. Obviously, if there was an earthquake, there would be a state of emergency declared. But for us to say we need an anti-price gouging ordinance, it hasn't been triggered. So unless Santa Monica has a special price gouging ordinance I'm not familiar with under state law, it hasn't yet been triggered. And I would like to work with City Council to make sure that we are protecting our landlords and our tenants, because if we are passing any of this cost through, it's going to cost money. And if we're not getting a fair price for these jobs, that ends up affecting potentially the tenant if anything is to be passed through. I also think we need to explore safe financial products. I'm not convinced that PACE is the best method. I see someone nodding no. There's been a lot of criticism of PACE. It's assessed against your property taxes. Up until the legislature just passed new legislation, there was no means testing. A lot of people didn't know what they were signing up for. I'm very concerned about highly advertising that as a feasible solution, which is why I was interested to hear about these FEMA loans. But again, direct our staff to work for us to convene with City Council around how the city could help to finance these jobs is really important to me in coming up to with a final determination about what, if anything, should be passed through. So again, not to belabor the point, I know it's late. The means and methods plan. How are we going to ensure there's open and good communication between building and safety and rent control board, such that there could be an expeditious and smooth process? I'm not feeling great about any of these means and methods plans. I haven't heard back from building and safety about specifically how we've improved our process with them. And I really think that, again, if this is difficult and time consuming, you're only going to get construction decrease petitions as this being taking unreasonably long periods of time. It's going to hurt everyone. And again, this factors into my decision in the totality of the circumstances here. So I would like to hear more from them. I would like to hear about how building and safety will determine if a temporary relocation plan is necessary for earthquake retrofitting, what is going to be the planning permit approval process. I would also urge the city to provide parking passes. We've heard this tonight. I would also like to hear more about any sort of potential subsidy from the city if there's some sort of landlord that isn't able to pay for the cost based on this fact that there may or may not be these 43 buildings that have all of the units occupied by long-term tenants. I also would like us to come up, if we are going to use a rent-burdened definition for rent-burdened tenants, what is that definition of rent-burdened? Is it the standard spending more than a third of your income on your housing, or is it something over and above that? I think these are all things that need to be worked out. I have more questions than answers, and I would definitely support weekly meetings if that's what it takes for us to resolve this by the end of the year, because public safety is my number one concern, equity is my second concern, and I don't think I have a solution yet. I have a lot of questions. Thanks.
Thank you very much, Commissioner Trosis. Commissioner Flora.
Yes, thank you. First of all, I also want to thank the public for your interest tonight, and of course to all of our legions of viewers. I know you're out there. No, sincerely, thank you for your interest, and particularly for sticking around knowing we're not going to vote tonight, but we will probably provide direction and requests of staff, such as was made by Commissioner Tarosis. Not every apartment building, here's where I stand on this so far. Not every apartment building is the same. Not every landlord is the same. Not every landlord owns the same number of apartment buildings or is equally as wealthy or not. So I think whatever solution we come up with has to delineate the difference between a company that owns 110 buildings in LA County, 30 of which may be in Santa Monica, and the mom and pops. There just has to be a delineation that appreciates those differences. That said, I'm open-minded on a lot of things. And of course, I appreciate Commissioner Tarosis volunteering us all for a bunch of extra meetings. No, but in all seriousness, we should. If that's what it takes, I'm willing to go to every neighborhood association and hear from residents. I'm willing to talk to building owners, property owners, as long as they are both large and small, not just multiple building ownership groups and LLCs and et cetera. We need to hear from the smaller owners. But I'm willing to do what it takes as well. And I really do think, as some of you have alluded to, it's going to really take a level of intergovernmental cooperation that really should be at the level of the crisis has already happened. Let's treat it like we're really needing to work together, to be in the same rooms. Obviously, all appreciating the Brown Act, but we've got to get together and not just learn what happened at the other meeting. You know, we've really got to, I think, be working in concert. To an unprecedented level to make sure we get ahead of this. I understand why the city provided an ample timeline. I think I do, to make sure that there was, first of all, also a further delineation in the types of buildings, what needed to be prioritized and what could wait, and to make it somewhat business friendly for our property owners. That said, you've got a sizable number of units that literally are going to be finished only a few months before the Olympics in Los Angeles. I could literally be a 14-year-old entering high school, complete high school, enter college, get a degree in engineering, and have my first job and still be able to get a little bit of work on the Santa Monica retrofitting because of this timeline. So I hope that what solutions we come up with might even encourage the ability for this process to move forward in a way that those landlords that aren't due till 2024 and beyond might be able to get ahead of it. I don't know how we do that, but this timeline is, we could have a couple of earthquakes before this thing is over. So with that, I'm now going to, with apologies, get into the weeds a little bit with the staff on a couple of questions about the report. Staff, right away on page 2, and I don't know if it's easy to put these up for the benefit of the public, but I will let them know that on page 2, the staff has put together building types, soft story of 2 stories, soft story of 16 units or more. And we come to about 10,800 units, and then there are additional types that aren't soft stories but are unreinforced masonry, et cetera, that get us to 12,000 units. Of the first 10,854 units identified as soft story, about 5,800 or 5,700 of them are 15 units or less. Now, I know you guys don't like to speculate, and I'm working with a lot more lawyers now than I was in the first few years of being on the board. But is it safe to say, or is it plausible, that as I'm looking at these 5,700 units that are 15 units or less, probably a lot of these buildings are only going to require probably a brace or 2 in the garage? Because we've seen the drawings of some soft stories that say have 7 spaces. Only 2 of those spaces will need to be braced. Is it plausible that a number of these are going to be literally 2 different steel braces and the job is done?
Go ahead.
It's possible that some will need no work at all. It's possible that some will need minimal work, and it's possible that some will need extensive work. It really is highly individualized based upon the engineering report. I don't think that we could say what is likely as a general matter across all of those buildings.
Okay, yeah, all right. Secondly, page 7, where regulations 4113 and 4113B were discussed. Folks, these were the regulations put in place after the Northridge earthquake that allowed landlords to ask for 100% pass-through. Are these active? And if so, do we need to revoke them immediately to implement a new process?
No, those regulations applied to ordinances that are no longer in effect.
Okay.
So those are not current ordinance or
Right,
regulations.
but those landlords are grandparented in, correct?
They were
And-
granted permanent rent increases for that work that was done, both the repairs and retrofitting.
Okay. Next, I'll try to get through these quickly. Page 11, where, and I know Lima's going to be feeling a chill down her spine because of the way, how much work she used to put into the old way of calculating rent adjustments every year before measured GA. But on page 11, it talks about, Lima, brace yourself, using a component ratio to gross rent calculation to figure out whether or not a landlord is rent burdened. So if the, say, pass-throughs are limited or do not happen, they could come to us and ask for this calculation. Could we, for the next meeting, evaluate whether or not we could implement a simpler appeal process for landlords that may want to prove that they're under financial hardship rather than this component ratio to gross rent calculation. I don't even like saying it. It makes, yeah. Is there something simpler? Because my guess here, and because here's my guess, okay? The landlords out there, particularly those that are usually the ones that participate in associations and don't think we really should exist, they aren't going to want us to see their books. Is there a simpler process that, for example, we could allow them to show the staff the books, and the staff would recommend to us whether or not, oh yes, trust me, these guys fit in category A, they're rent burdened. We wouldn't see their numbers, they'd feel safer therefore showing them to you, and we'd vote based on your recommendation because we trust the staff. Just as one example. In other words, could we explore ways we could avoid this component ratio? I'm saying it again, and I feel like it's a swear word. Component ratio to gross rent calculation. Are there other methods that could be simpler for the financially burdened landlord to come forward, show us some numbers, and expedite perhaps some relief?
It may be possible that we can come up with simpler methods, and we can certainly, staff will talk about that. But
yeah. Can we just explore what's out there? Yeah.
Yes, but when the board makes a decision, the public has a right to know the basis on which that decision is made. So it would not be appropriate for the board to just take staff's word for what the evidence was.
I understand, and I'm completely for transparency, and that absolutely believe the public has a right to know. I'm just trying to think of a system that would be simpler, and that would, my guess in Berkeley is landlords don't want to show the numbers, and that's why they're not coming forward to this complex process of. And I'm speculating, and I could be wrong, but my request in general is, could we explore some simpler processes? Are they out there? Do they exist? Are there models?
Well, what we were thinking with that was that we could try and create, look at some of the actual buildings for which we have the data of what the return was in 1978 or 79, and look at, based upon the information that we have about current rent levels and making some assumptions about some of the other property owner expenses, try and identify what type of buildings might qualify for an increase under the net operating income analysis. So we were going to use that kind of structure to try and assess these actual buildings. So if you'd like us to do that, we could work on that for the next time we talk about this. But we would not have actual information. We would be making assumptions about what these, what their expenses are, because we don't have that information.
But it could be helpful to go through some hypothetical models.
To try and assess, like, how many of these properties really are, or these property owners are really in a hardship situation. Yeah.
I think it would help me make certain decisions, and I know we can't take them as gospel.
Do you want to add anything to that, Lima? Yeah. Do you want to? Yeah. Sorry.
Yeah. And while you're at the microphone, maybe speak to this issue. Was it Mr. Millman or somebody brought up the clawing back to 30 years worth of records? I think obviously some owners, 27% of which we saw, have bought in the last 7 years.
Well, but when we do an NOI analysis, we're looking at the return on the property in 78 or 79, 1 year before rent control, and the return now.
Okay, so it is actually easier to do than was presented?
Right, and in some properties, as Mr. Jacobson mentioned, owners, when they registered the initial rents, they were also supposed to fill out a financial statement that explained what their operating expenses were. Not everybody did, but we have some of those, and so we're looking for these properties, which ones filed that financial information so that we have that baseline expense.
That's where you would be basing these assumptions for the next meeting. Okay.
Do you turn her on, Steve? Or?
I got it.
Yeah. Okay, Lonnie.
Thank you.
Okay. That is how the NOI analysis is done. Most owners who file an increase petition do not have the 78 information, and we do rely on the registration form. No one gets documentation from 1978 unless they happen to have it. It's assumed to be correct, and that's those hundreds of increase petitions that we processed, that's what we used. What we would need documentation on is the current year expenses. and people do have to have the documents in order for that. We were looking at the idea of from the properties on the soft story properties to see how many of those have data from the registration forms, so we could do a model of, for 1978, what's the NOI basis? And as Ms. Condon had mentioned, making assumptions in a current year analysis on what those costs would be. We can get the income, we can get some property tax information, we can get some detail information, the rest we have to make assumptions of.
Yeah.
Just factoring in the cost of the soft story
Right.
would be one of the expenses we could look at.
Within that, is it possible to delineate number of sales of building delineations versus the person's owned it? Oh, yeah, I think we had that in one of the tables, right? The 3%?
Yes.
Okay.
Yes.
So we have
Yes.
that. Okay,
Yes.
great.
Yes.
With that, Mr. Chair, I will yield.
Okay.
Thank you.
Thank you, Commissioner Flora. Commissioner Phyllis.
I can be really quick. This is just direction for staff.
Okay.
So what I would like to see coming back next time, ways that we, so this is how I'm thinking about it. If we do pass through anything at all, I don't think that it should be the general rule. I think it should be an exception to reward some sort of either to accommodate a hardship for a landlord or to reward expedited retrofitting. That is the only kind of way in which I think any sort of in which I'm currently kind of open at all to contemplating pass-throughs. So can we limit pass-throughs to post-2008 tenancies or people who are already paying higher rents? Can we talk about pass-throughs? And this is, I do want to see, looking at the amounts of pass-throughs versus other pass-through amounts, specifically the bonds and the tax pass-throughs. Those, I mean, that's really important to me. I do not want to talk about seismic retrofitting pass-throughs without talking about the other pass-throughs, which are pass-through 100%, correct?
They are.
Okay, so, just to be clear, like, that is not consistent with a lot of other jurisdictions, correct?
That's correct. Most other jurisdictions do not have that type of pass-through at all. It was something unique to the charter amendment as it was originally adopted. That has been changed now, so the board does not have the same legal requirement to pass those particular bonds and assessments through the way we did in the past. So we certainly can bring back information about that. Is the rest of the board interested in tackling this issue simultaneously?
I mean, look, for me, that's part of a
Yeah.
critical part of the analysis. If we're talking about what additional costs are tenants being forced to shoulder, I don't know how we're talking about a retrofit without talking about, look at the bond amounts. I mean, like, if the cost of a retrofit is $10 a month, but a tenant is already paying $120 a month with all of the bonds and all of the other taxes that are being passed through, I want to understand that. I mean, that is part of my analysis. So
Can I just say something about that? I understand what you're saying and I agree with you. I just would hate for that analysis, which appears to be a little bit more in-depth, even though this is an in-depth analysis. I would not want that to slow down
I don't want it to slow it down.
our
but I mean,
process. Because I think timeliness is also important.
Right. I mean,
yeah,
but
no,
I
agree.
want the information.
I think that we could, for these properties, we could tell you what the current pass-throughs are. I think we could gather most of that information and give you a sense of what the other pass-throughs are.
And specifically what I would like to see are, give me 10 examples of buildings that have recently turned over, and I want to see the differences between what the pass-throughs were prior to turning over and what the pass-throughs were after turning over. Because if that's a substantial threat, if we're going to limit the amount of pass-throughs, that does affect my analysis 100%. So I also want to look at incentive programs for prompt retrofitting, and I think we need to look at that holistically. So I really do want to hear a commitment from the city on preferential parking permits. I really want to hear, I want to hear about what a staggered pass-through program would look like if we're talking about rewards. I don't think the 94 retrofit program is like even remotely a comparable analogy, because we're talking about prospective retrofitting versus responsive or reactive. And that wasn't, if I'm correct, the 94 issues wasn't just retrofitting, it was for repairs, which that was the overwhelming majority of what we're talking about. We're talking about saving buildings that were red tagged, that were rent controlled to preserve rent controlled housing stock, right? So like it's a fundamentally different analysis to me, even though I understand people are talking about it in the same way because it's in relation to an earthquake.
Yeah, and those 1,000 petitions were not all on buildings that were red and yellow tagged.
Right.
Some of those were buildings that were still habitable, but repairs needed
damaged,
to be made.
Right. But I am correct in retrofitting was not the majority of the.
That's correct.
Like overwhelmingly.
That's correct.
Okay. I really want concrete information, and I would direct staff to work with the city on a loan program. Like, what would that look like? Are there any other jurisdictions that have implemented anything like that? I really do want to lead. I would love to be in a situation where we can count on our city to ensure that people aren't turning over their buildings, so that these are getting retrofitted and we're not passing on the cost to the tenants. That's like the ideal situation. So I want to work with the city to make sure that happens. So. I'm serious about low cost, no interest, low interest loan programs. I want to look into whether there would be a disqualifying provision for any building that has turned over within a recent number of years for a pass-through. And the reason why that's significant is the property value has obviously been reassessed and has gone up. And I also would want any building that is turned over post the mandate on retrofitting to disqualify for a pass-through, because if people are looking to sell their buildings to circumvent implementing the retrofit law, that's something that I think should not be rewarded with any type of pass-through. Understood?
Well, you say disqualify any building recently sold. I understand your second point, anything post the mandate, but what are you referring to?
And I would also be interested in looking at recently sold buildings, so buildings that have recently turned over.
Like 2015?
Yeah, I'm interested in both post-mandate and recent within the last 2 years, and whether that is something that is legally supportable, whether that's something that, would work for us. Sorry, do you want to tell me?
Can I just jump in and clarify? I think what Commissioner Phyllis is referring to is something like what the San Francisco folks did with but only if the tenancy began at least 6 months before.
I'm talking about sale of the building, not tenancy.
That's on the tenants, but you're talking about on the landlord.
I'm talking about if a landlord sells the building to another entity.
Purchaser.
And so what we've heard from landlords
which means
is,
they've got a lot of money.
I just want to turn over this building because I don't want to deal with the retrofit. Well, that means that someone else is going to have to deal with the retrofit. And if you're passing that on to someone because you don't want to deal with it, I think that there should be limits for the amount of that the subsequent purchaser should benefit. I mean, I would be very, very, if there's a way to disqualify buildings that have turned over since the implementation of the mandate for pass-throughs, I think that's something that I am interested in. Okay. I, again, support Commissioner Teros's. We need to come up with a clear definition of what is rent burdened. I also want to come up with a clear definition of what is income burdened or income restricted from the point of a landlord. I want it to be very clear. I want it to be empirical. Let's see. I want to look at, limiting buildings that qualify for pass-throughs, if we do consider it at all, based on maybe percentage of post-Costa-Hawkins units, based on, again, duration of ownership. And then, I would like some clarification, because it's really difficult to understand how we define reasonable return. And I guarantee if I'm struggling to understand it, a lot of other people are struggling to understand it. And I want to know if we've identified how many landlords are making a reasonable return, because there seems to be a lot of disputes over that.
We don't have their expense information, so we don't know that. I said we could perhaps develop some models, but we don't have every property owner's expense information. We have their income information. Yeah.
Yeah, I mean, whatever we can do to try to get information on that, I want to understand it, because, like, this is asking for either financing or out-of-pocket expenses, and pretty significant out-of-pocket, or could be asking for significant out-of-pocket expenses up front. And I am really, really concerned about buildings turning over because of this mandatory pass-through program. Like, I'm telling you, that is my first concern, because I think it's going to slow down the retrofitting process, which inhibits that hurts public safety. And it's going to have the unintended consequence of, when these buildings turn over, either losing our rent-controlled housing stock because they're going to be Ellis'd, or having tenants who are subject to much, much higher pass-throughs on the other bonds and taxes, potentially far more than the amount that we're talking about on a pass-through. And I want a hard number on a cap. If we were to come up with a cap, I want to know what it would look like, and how we would calculate it. Because we've seen caps of $30 to $38, but those are for two different, right? Mm-hmm. Whichever is greater, mm-hmm. Los Angeles and San Francisco. And the $38 cap, I think, was for...
Well, the $38 is Los Angeles, and San Francisco is $30 or 10% of the rent, whichever's higher.
Greater.
Mm-hmm.
Right. So I want to... How would we figure out caps? And I know that we have to do it kind of creatively, but we need to start talking about it in very concrete terms if we're going to get it done by the end of 2017, which I want to do.
I have a question for you. Would you be in favor of us being informed by some sort of working group or committee of experts to propose solutions to this?
Yes.
All right.
Do you have something more specific in mind?
Wait a minute.
I don't know. I mean,
hang on
sorry.
a sec. Commissioner Phyllis has the...
That's all. That's
You're
my
done?
list. Yeah.
All right. You can put yourself on the queue, and then I just want to keep the order here, and mostly because I'm next. Okay, so I wanted to say that I think this is an absolutely fantastic start to the very complicated and long discussion that we're going to have. One of the things that struck me, something that I would ask staff to consider, is that whatever solutions we come up with, and there's a lot of fabulous ideas that have come out by people who have spoke publicly as well as my fellow commissioners, that whatever the solutions are, they have to be in an objective, non-discriminatory way because of the agency that, we're a government agency, et cetera. So that may tailor or curtail or enhance how we come about these solutions. Just want to make aware of that. I also like the idea of proactively making ourselves available to hear more. We had a wonderful audience tonight. Great many different speakers spoke, but I think that there is a huge community out there that hasn't had any opportunity to speak, that may want to, if we can make ourselves more conveniently available to them. So, much to my chagrin, making ourselves open for weekend hearings, more than monthly hearings, whatever we can do, speaking at or putting ourselves on community group meetings so that we can hear what they say. In other words, going to them to be proactive about hearing what they might have to offer. The solution would be a good idea, I believe. And I was also taken aback by, when we first discussed this, how long this process is. And I agree with all of my commissioners that safety is a number one concern for me. And so finding ways that we could expedite this process, I think I don't want to repeat all that has been said. I guess it's one of the great things by trying to speak last is you hear all the great ideas, so I don't have to repeat them. But I think there were several ideas that came up about what we can do to try and expedite the process, whether it be assistance with finances, talking to council about low-rate loans or no loans, and in the hope that that would expedite the process. I think Commissioner Phillips brings up some wonderful ideas about concerns regarding the consequences this could have in terms of landowner or apartment owners being forced to sell. I think that the result of that could be catastrophic in an unintended consequence that we don't want to have happen. So I think there's a lot of great ideas. I know that we are not done with this discussion. I also know that we have another issue to discuss after this one. So
That's quick.
That's
quick? Okay. All right. Having said that, I've said my piece for tonight. Commissioner Foster, you are next.
Thank you. I too am enjoying the very robust discussion of all of the concerns that the public and the board have. A couple things throughout all these comments that made me think of some other things. First of all, the Housing Commission, I attended a 4.5-hour meeting one week where they discussed extensively the requirements for qualifying for POD aid, for instance. And to some of the questions about how can we ascertain levels of income or levels of rent-burdened condition, I think we can avail ourselves of the weeks and months of work that the Housing Commission has already done in drawing parameters for Santa Monica residents. They looked at utility bills, groceries, average medical expenses. I mean, for tenants to truly determine a rent-burdened status. So I think if we're looking for income measurements that might affect, for instance, what some of you were saying was, can we ascertain, landlord's rent, property burden versus a tenant's rent burden? At least for the tenant side of it, that might be a resource for that type of information. Another thing was, do we have any way of knowing? I know that whenever I call and ask you about a constituent's concern about a building or something, you're able to tell us the public records of the transactions a building has gone through. Can we ascertain how many buildings that were either red or yellow tagged or not, and were simply retrofitted proactively after Northridge, in a short period of time after Northridge? Can we ascertain how many buildings turned over? We may not know the reason they turned over, but can we look to see if there was a spike of real estate activity after Northridge? So that rather than deal with a repair or a retrofit, maybe a property owner just chose to sell instead. I'd be curious if there's just, I understand again, we can't know the reason in looking back, but see if there was a measurable spike. It's not an apples to apples comparison, but it was just a thought due to some of the concerns up here. If you tell me that's a stretch, then that's fine. Also, I feel that we've had several emails and talks about perhaps, speaking of the POD program, which is the Preserving Our Diversity Rent Subsidy Program for rent-burdened tenants, we've seen some suggestions from the landlord community that money be used to subsidize the retrofit expense. And I would just strongly urge solutions for rent or for cost-burdened landlords to look at more of subsidizing the landlord side of it through low or no-cost loans, rather than subsidizing the entire retrofit on the tenant side of it. That's my personal opinion, but I don't feel that money should be double-purposed. So I would strongly urge us all to look at ways to subsidize needy landlords before we look at subsidizing the entire retrofit through tenants. Also, I would like for staff to tell us if they could do perhaps bi-weekly, every 2 weeks, you could do one of those fabulous PowerPoint presentations with a quick question and answer session that you do at the library. You do it quarterly for various things like maintenance and repairs, and you just did one for seismic. Can you do more? Can you do more that we can promote for tenants and landlords to attend? Can you do more sessions and calendar some more sessions?
Yeah, we have not done a seismic one yet because part of that is figuring out what is it that, we're going to tell the tenants, but we are looking for
as far as input.
Input, right.
Yeah. Mm-hmm.
So yeah, we could create a seismic,
couple more?
A seminar about that, and I don't know that we could do them bi-weekly, but we could create a seminar about the seismic retrofitting program and the requirements. As I said earlier, the city will be offering 4 information sessions specifically for owners and tenants of these buildings. The first one's November 13th. There will be 3 more over the course of the next year in different areas of the city. So they want to get the information out about the program as well.
So thank you. So, that'd be great. So the last thing is, I do feel tremendous agreement that we should have some sort of a public session, so there's no Brown Act issue, a public session where we engage with either building and safety or city council members or city staff. That's a public meeting. That is a roundtable discussion. I think with one lengthy roundtable, we could perhaps get a lot of our questions answered rather than making staff run back and forth and back and forth and back and forth a month at a time. We could probably handle it in one marathon and get a lot of questions answered so that we could move it along more quickly. I would second that emotion. And the last thing I'll ask is that can the staff tell us also next month what costs in payroll and labor hours for your staff are all of these? We're throwing a lot of direction at you tonight. I mean, I've heard no fewer from all of us than 12, 15 different directions to staff. We just want to make certain that we're not overburdening you, and that if we need to prioritize, while every commissioner certainly has the right to direct staff to do whatever they want, I want to make certain that we're not burdening your staff to the point where we're encumbering the process. Sure.
Which is one to clarify that it's not the case that any individual board member can direct staff to do whatever the individual board member wants. Only the board as a whole can do that. Any individual board member can direct that something be put on the agenda, but it's not lawful for individual board members to direct staff. That's something that has to be done as a body. In terms of the direction that the board has given tonight, this is all stuff that we've already put some thought into, and it's eminently doable to answer a lot of the questions. But I do have the primary thing that staff needs from the board in order to provide recommendations on which the board can act, much of which we've gotten tonight, is a statement from the board members about what values the board wants to promote in enacting a pass-through, if any. And we've heard things like incentivizing the work to be done quickly, and also avoiding inappropriate burdens on tenants who can't afford to pay, and also avoiding inappropriate burdens on landlords who can't afford to carry the burden without some sort of assistance of doing the work. So all of that has been very helpful, and I think that there are a lot of recommendations that we can put together already, but you've also asked for some information, and we can pull that information together that will help further that process along as well. But I have a clarifying question, Mr. Chair, if I may ask. Several of you have mentioned that you want to ensure that we have a regulation in place by the end of the year. Several of you have also said that coming up with a regulation will depend upon action by the city council with respect to low interest loans or other incentives that they may provide for landlords. That may or may not, I do not believe that it's realistic to think that the city council will, by the end of this year, do those things. So in order to help us evaluate our timeline, which is more important, waiting until we have those answers, or having regulations in place by the end of the year?
Well, I think that having the information to make the regulation is crucial. But let me ask you this. We make a regulation and then we get additional information later because maybe the council isn't ready to make the decision. We can then amend our regulation to incorporate their input or their changes or their suggestions. Is that right?
Yes. One thing to be cautious about doing that, it's definitely the case that when the board enacts a regulation, it can change the regulation. But to the extent that one of the values that the board seeks to advance by enacting a regulation is getting work underway quickly, if people undertake work based upon a regulation that the board has put in place and then the board changes it, that will cause some issues. So while regulations can be refined, it does not make sense if you think that you don't have the requisite information to make sound regulations. It's probably best to wait until you have that information. But if you think that you can put the basic structure of regulations in place and refine it further as you go in ways that don't get to the heart of it, the board can certainly do that. Is that responsive to your question?
I think so, yeah. One thing that maybe to consider, there's a lot of things that have been thrown out, and I can't remember all of them at the top of my head right now to really give a clear outline or even strict numbers on what should come first, second, third. I don't know, maybe coming back to the next meeting, it makes sense to put all these things together in a way that we can read it, analyze it, swallow it, and kind of put some structure to all of the suggestions that have been thrown out. Okay. Well, discussion on my point. I'm just spitballing here. So if anybody has ideas that think it's good or bad, please let me hear it. Go ahead, Commissioner Flora.
Yeah, I wanted to speak to 2 points, and this one I wanted to get to right away. Commissioner Foster's point about overburdening and Stephen's point about arbitrary deadlines, I want to speak to right away. Colleagues, I appreciate your ambition. I'm no less ambitious than I was when I walked in here in December of 2010. But I remember in my early days of activism in Santa Monica, I don't remember who I was talking to. It might have even been Councilmember McCune and then first term Councilmember McCune. Somebody, and I said, I don't understand. You guys are up till beyond midnight every 2 weeks. Why don't you just meet every week? And I was reminded that they're directing staff to do a lot of things. Staff is human. Staff needs the time to get us the answers we need to make responsible decisions. So this idea that, I don't know, we're going to meet on Thanksgiving or we're going to meet every week, I appreciate the gumption, but the idea that we have to make a decision by the end of the year or somehow it's not responsible, I think it's only responsible if we take the time we need to get the answers we need, to be a good teammate with these other bodies of government that we say we want to work with and work on their timelines, that we're not putting staff, both cities and our staff, into overtime situations. I'm not saying go slow. I'm saying there's ambitious and then there's rambunctiously reckless. And you've got to allow the time to get the information we've asked for. So let's please respect that. I totally respect everyone's gumption and enthusiasm to get the public some answers. I want to get them the right answers. Let's form the committees. Let's ask for joint meetings. Let's do what we need to do. I would by all means be willing to have another meeting before November 9th to hear some sort of structure. But let's realize we've asked these folks to do a lot. So this meeting every week and, let's do this right. My second point, I just want to quickly, and again, I really think we're hitting diminishing returns here, and I do hope that we recognize we've made a good start tonight. Everybody wants to get their last chits in, but I do have to say this. I really need to back up, as I started to earlier, Commissioner Phyllis's idea that some people have proven themselves quite well off and really just should not qualify for a pass-through, if pass-throughs are even where we're going. The building next door to mine was purchased either early this year or late last year. 6 units, 4 are now vacant due to buyouts. The 2, I won't use the other word, but the 2 residents who I'm familiar with and converse with that are remaining are at the very least pestered consistently with buyouts and untimely sawing and other construction work to fix up these units. The building was purchased by, I understand it, a very wealthy doctor who not only able to construct and rebuild and completely refurbish this building, but has hired Caldwell Banker to manage it. 6 units. If this was a soft store building, and it's not, and probably had, let's say, 6 spaces, there is no way in hell that this guy cannot afford the retrofit after doing what a lot of people are doing right now, which is paying over asking, buying out their tenants, haranguing the other tenants, and making massive improvements. There is a population of recent buyers that are just not going to convince me they don't have the money. And I think these people do not warrant a pass-through, and that's only if we consider a pass-through process. And so I just wanted to back up what Commissioner Phyllis had to say. And that's it for me. Thank you.
Thank you, Commissioner Flora. Commissioner Trosis. Oops.
I just wanted to answer Stephen's question. I don't think it's a hard stop on the end of the year. I think I was just trying to demonstrate that moving efficiently is important. I obviously think getting the right answers and doing the right thing is more important. I can't say for 100% certain that I need to wait for City Council to do something, because I'm not 100% convinced that City Council will do something. That might be slightly out of our control to say that we are going to make City Council do something. So I think we have to just kind of see how it goes. And if we're not getting anywhere, we're going to have to just act. But I would like to make an honest effort to talk with Building and Safety and City Council. And you asked what my priority was. I think my priority is public safety, and my priority is equity, whatever that might mean. So with that being said, I want to make a motion because I do want to formalize some of the things that I stated tonight so that we can actually direct staff. So I would like to move to direct staff, in lieu of creating some sort of advisory body. I'm going to move to direct staff again to calendar the special weekend meeting of the Rent Control Board, where we invite, I guess this is open to discussion. I'm going to first say, if you want to amend it and have 2 different meetings, that's fine, but where we invite City Council, Building and Safety, and other recognized community leaders to engage the board in a roundtable discussion to propose solutions to the cost of retrofitting. I'm also going to move to direct staff to prepare a survey and advise us as to how to disseminate said survey to hear from the community in a linguistically appropriate manner, and also direct staff to prepare a social media and public outreach campaign so that we can make sure that at each of our meetings, however often they may be, we are hearing from the public, and then finally direct staff to come back with a proposed schedule of meetings for all of these items to take place.
Are those separate motions, or?
I mean, it's like one motion with multiple calls of the motion. Yeah.
Well,
I was going to
okay.
second your first one, but then they were
Sorry.
coming rapid fire. So
I think maybe we should break them down.
Sure. Okay, so the first one is
the roundtable.
Calendar the weekend meeting, invite City Council and Building and Safety side note, I'm very concerned about what building and safety is doing. Where we
Depending on the scheduling of that and which weekend it ends up being, I would second that motion.
Yeah, obviously to be scheduled at a agreeable time.
Second.
Okay, wait a
Can I
minute.
ask a question?
There's a first and a second. There's this. I
Oh my God!
there's
I
a,
tried
the
to
question
do
for
all of them
discussion.
together.
Go ahead, Commissioner Flora.
No, she's ahead of me.
Sorry, Commissioner Phyllis. Go ahead.
All right. Because we're giving direction to staff, because I just we're giving direction to staff. I don't know that it's necessary to formalize everything. I think we can ask if anyone has an objection to any of the points that you have in your motion, and if there's kind of a majority of the board
do we have
that's
a
open.
consensus on all of the items that I laid out?
Or is there any objection to
Is there any
of the three?
objection?
Well,
go ahead. Wait now, Commissioner Flora.
Not an objection. I want to make sure that a lot of these things we've asked for also get put together, like modeling, like how a loan program would work, and
Right.
a lot of those things, in addition to what you mentioned. But you know, again, and I'm gung ho, but one of the first surveys we should probably conduct is whether or not building and safety and the council and other city staff's going to show up for you on a Saturday.
Okay,
I'm serious, guys. I mean, we got to think this through. I know we're gung ho. We may show up. We meet once a month.
Okay.
But these folks are under a different. You work for the county. You know there's overtime issues. You know that they may not favor the idea. So how about a meeting?
No, I don't.
TBD.
Okay, a meeting at a mutually agreeable time to be conducted in the most expeditious manner possible.
With the suggestion that it happens on the weekend.
But if not possible, we'll do it during the weekday and additional engagement on the weekend.
And okay.
Okay, so that's your motion.
There's no motion. We're just testing to see if there's an objection. Carolyn gave 3 points to direct staff. One was this meeting. Can you repeat the second two?
One was the survey, one was
social
the
media.
public outreach social media campaign, and one was a timeline of meetings.
Okay, so we have the direction to staff.
No, wait a minute. Okay, wait a minute.
But I did want to respond to Stephen's point, which I think is kind of getting away from us because there's a motion.
Right.
And then
Right,
the motion
right.
was
I know.
rescinded, and I really do want to speak to it.
I understand, and you can.
Okay.
My understanding is that the motion has not been rescinded. So
No, I did not rescind it.
okay, so there's a motion on the floor.
Oh.
Is there a second?
I'll second it.
Okay, motion and a second. Any other discussion on it? Okay, well,
I'm sorry. I just need clarity as to whether or not all those additional requests are going to be also considered. So it's not just social media, but also the points Nicole made about who's eligible, the things we
Yeah.
made about the 3%, the loan program.
Yeah.
Is that also thrown in
well,
as things that will be fact found?
It's her motion.
So,
and she's
Carolyn, would you agree that all those things in addition?
Everything we've discussed.
I don't think Carolyn felt.
I think it's a fair question.
Carolyn felt like she needed to formalize her direction to staff in a motion. I feel like I don't need to formalize my direction to staff in a motion. It's fine. I seconded the motion. Can I call the vote?
Yes, call the vote.
Okay.
Okay, let's do a roll call, please.
Commissioner Foster?
Yes.
Commissioner Flora?
Yes.
Commissioner Phyllis?
Yes.
Commissioner Trosis?
Yes.
And Commissioner Drawn?
Yes.
Great.
Can
Okay.
I please speak to Stephen's question?
Yes, please.
So I understand that there are limitations. We don't have control over city council. I spoke with Councilmember McEwen, who has graciously stayed through the end of this meeting, who told me that he, would be interested in talking to staff about am I correct? I don't want to put words in your mouth, Councilmember McEwen, but we did speak briefly about the possibility of discussing a loan program. Is that a fair characterization? Yes, please.
Yes, please.
I am here on my own time tonight, not representing the council, but with the intent of being a conduit to the council for the conversation that's happened here tonight, and to express the willingness of at least one council member to be cooperative with the Rent Control Board in finding solutions to the hot potato we handed you. So that's why I'm here.
Would one solution be exploring the possibility of a loan program?
Well, I brought up the fact that I'd be open to discussions of that idea. Now, I can't guarantee you what the rest of the council will think, I want to be clear, I'm not talking about taking money from, for instance, our tenant in distress programs
Yep.
or anything like that.
Right.
I'm talking about loans, I'm not talking about subsidies.
Yep, yes, yeah. I think it's so wonderful that you've stayed here, and I can't express enough how
Well, I'm used
grateful
to
we
being
are.
here
I know, right? This is an early night for you.
I'm sitting you at 9 o'clock saying, oh, it's so late tonight. And I think, geez.
We're a little
We're
spoiled.
just warming up. At 9 o'clock. Does that
but-
help?
Yes.
That's great.
And I'll sit and listen to the rest.
Thank you.
Thank you.
But
Thank you so
I,
much,
you know,
Bruce.
I think that we've seen an incredibly, you know, one strong commitment from at least one council member who, you know, is willing to help bring the ideas forth that we've discussed. And, you know, like, look, if it means that we can't get it done by 2017, I understand, but I work under deadlines all the time, and I think we're far overdue. So if it means that I have to be the obnoxious one being like, why is this taking more time, then I'll be that person, because I think we need to push this. So, you know, like, I think the goal is for me by the end of 2017, and I'll convey that to council, and I will go to the council meeting, and I will speak at public comment, and I will say that because if the big one happens between now and whenever we implement this program, there is responsibility, and I feel like we really do need to push. So I want to make no mistake, timeliness is an issue for me.
Yeah, so just to clarify, I think at the time this is an issue for staff as well. It's just that I just wanted to know what the direction was, because on the one hand I heard it has to be done by the end of 2017, and then on the other hand I heard that decisions couldn't be made unless the council made decisions. I just needed to know which it was. So
I think the goal is have a very clear idea about a concrete proposal by the end of 2017. And I think that also means expressing that to the other bodies that may be involved in that proposal. So part of that is going to council. We have a council member here tonight who I have absolutely no doubt will be able to convey the ideas far more eloquently than probably any of us have tonight. So like 2017 does matter for me. And if there are contingencies, and there are contingencies, but I want to see a concrete plan as close to the end of 2017 as possible.
Okay. Let's move on to item 12B, the final budget report for fiscal year 2016 and 2017.
All right, this is just an information item. It doesn't require any board action. The written report is very detailed, and we've had a long meeting, so I'm not going to go into much detail. Last year, the board adopted a budget of $5,026,000. There were no additional appropriations or modifications in the budget during the year. We had projected revenue at $4,657,000, and that left us with a projected deficit of $369,000. We were fortunate in that we collected $55,000 more in revenue than we had originally projected, and we reduced our expenditures by almost $115,000. So we were able to reduce the deficit to just short of $200,000, and that will be covered by the board's reserves. So just a report on how the last fiscal year ended, and if you have any questions, I'm happy to answer them.
Any questions? I see one, Commissioner Flora.
Just because I asked this of Tracy before the meeting, I want to share with my colleagues what I asked her, which was these numbers look pretty good considering that huge workers' compensation bill. Well, guess what? This budget that you're looking at doesn't even include that sticker shock yet. So I'm happy with the size of the reserve. It's larger than what I started with in 2011. I'm glad we got the deficit down, but just know that big bill for the workers' comp, not in this.
Right.
Just FYI.
That's this year's budget.
Yeah.
That's correct.
Very good. Okay, thank you. Seeing no other questions by other commissioners, I'm moving on to item number 16, adjournment.
Move to adjourn.
It's been a motion to adjourn. Second? Okay, there's a motion and a second. All in favor?
Aye.
Aye. Okay, see everybody November 9th,
Do you
2017.
want to set a meeting before?
Or before.
Where it is?
Oh, yeah. Yeah, let me.